Yes, Mr. Sherman.
Commissioner, our first witness today is Dr Andre Oboler.
Yes. Good morning, Dr Oboler.
Do you wish to give an oath or an affirmation?
An affirmation, please.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Dr Oboler, have you given a second report to the Commission dated 28th of June 2026? Is that correct?
I have, and it's absolutely huge.
Thank you for the work that's obviously gone into that report. Commissioner, the position with respect to the tender of this report requires a little bit of explanation.
Yes.
I'd seek to tender the report at stat.899.0001.0405 together with a bundle of material referred to in that report, subject to the following.
Yes.
There are some exhibits that are platform statements that are the subject of ongoing confidentiality discussions, and so it's proposed that those specific exhibits would not be tendered at this stage, but would when those confidentiality issues are resolved. I could indicate those exhibits to you. They are 3-059, 060, 064, 068, 083, 084 and 087. So subject to not tendering those statements at this stage, we would propose to tender the balance of the materials.
Yes, that's noted. Do I take it that the parties at the bar table each have a copy of the exhibit list for today with the numbers? What? And Mr.
For the state of New South Wales, I don't have one yet, but something's just been handed.
All right. Well, I think, if people are to be able to meaningfully follow the proceedings and the tender, we need to make sure that each of the parties has a copy of that exhibit list. And then, Mr. Sherman, I'm going to ask you to again indicate those items identified as appendices to it that are not the subject of the tender at the present time. And once that's done, people might be relieved to know I'm not going to give each an individual exhibit number. The numbers will be as per the list.
Certainly, Commissioner. I am told that a soft copy has been provided, but we're content to proceed in that way, and I can provide a general indication that they are the platform statements.
Right. Would you mind just running through?
Certainly. So the exhibit numbers are 3-059, 060, 064, 068, 083, 084 and 087.
Yes. Is everyone content at the bar table that you now have an understanding of what has just been tendered?
Yes.
Yes. Yes, good. Very well, Mr. Sherman.
Thank you, Commissioner. Now, Dr Oboler, you've previously given a statement to the Royal Commission in hearing block 1, is that correct?
That is correct.
And for the benefit of the transcript, I'll just note that that statement bears the document ID STAT.899.0057.0022. That statement was dated the 8th of May 2026, is that right?
I believe that's right.
And in that statement, you gave evidence about the Online Hate Prevention Institute and your role as founder and CEO of that institute, is that correct?
That is correct.
Now, I don't need to go back to the detail of that statement, but it's correct that the Online Hate Prevention Institute is a charity and recognised leader in tackling online anti-Semitism, is that correct?
That is correct. Online hate in general and anti-Semitism in particular.
Certainly. And you yourself hold a PhD in computer science from Lancaster University in the United Kingdom, is that right?
That is correct.
And a Juris Doctor and Bachelor of Computer Science with honours from Monash.
Correct.
And you've served as the chair of the Global Policy Caucus of the Institute of Electrical and Electronics Engineers, is that correct?
The IEEE it's known as.
And could you tell me a little bit about the pin that you're wearing on your lapel today?
This pin is known as the Golden Core. It's the highest service award from the IEEE Computer Society. That's the part that deals with computing technology.
Thank you. And you're an expert member of the Australian Government's delegation to the International Holocaust Remembrance Alliance, is that right?
That is correct.
and you've worked on efforts to combat online hate since 2004, is that correct?
That is correct.
And you're also an adjunct associate professor in the law school at La Trobe University, is that right?
Yep, that's correct.
Now, dealing with your second report, which is the report we're here to discuss today, but by way of overview, the first aspect concerns the provision of representative samples of anti-Semitic content across social media platforms, is that right?
That's correct. I was asked to provide samples on 7 specific platforms, and the evidence covers that.
Thank you. And then the second question that was posed to you asked you to provide observations on the overall responsiveness of platforms in identifying and responding to the presence of anti-Semitic content in their services. Is that right?
Yep, that is correct.
And the third question asked you to comment on material differences in platform policies and reporting mechanisms. Is that correct?
That's correct. I've answered that partly in the second question in terms of individual platforms and how they respond, and then summarised in that third question the differences.
Thank you. And in terms of the fourth to seventh questions, in general terms, they asked you to provide comment on the policies and procedures adopted by platforms, government responses, access to platform data, and risks arising from generative artificial intelligence. Is that right?
That's correct.
Now, just before we get into the substance of your report and your observations regarding the platforms, I wanted to ask you a few questions just to understand the methodology that was used in obtaining and categorising the anti-Semitic content that you've provided to the Commission. Do you understand that?
I do, yep.
Now, in your first report, you gave evidence that the Online Hate Prevention Institute monitors the online environment to identify content that's anti-Semitic. Could you just briefly recap what that monitoring involves?
Yeah, so our monitoring approach is based on a time-based system. So we apply the same amount of time monitoring each of the platforms using a specific methodology. That methodology starts each hour of monitoring by doing a search. We find an item of anti-Semitic content on the platform we're examining for that hour. We capture that particular item, take a screenshot of it. If it's a video, we download the video. We record the URL. The system automatically records the current date and time, and it's classified according to our 27 different subcategories of anti-Semitism. Once that item has been recorded, we then go through the comments on that item, checking them, capturing any of the comments that are anti-Semitic. When we're done going through the comments, if the hour still has time left in it, then our staff look for one of the people who engaged with it, either with a comment or a like or a share. They go and look at that person's profile, see in a very quick glance, is there something anti-Semitic that person's posted? If so, they capture it and start going through the comments again, and they keep snowballing in this way until the hour finishes. Once the hour's finished, they then move on to the next platform and they repeat the process for an hour. We normally limit the staff to 1 to 2 hours a day doing this, so 1 to 2 platforms. So yeah, this is how the sample's collected, and then the sample that's been provided to the Commission, there's 2 steps to it. We're asked for a representative sample for each platform. So what I did was I looked at the average number of items that we have for each of our 27 subcategories on each platform, and then started with a sample size of 500 and said proportionately how many of each of these categories do we need. And when it was coming out with a very small number, we rounded it up to 6 just to ensure there was enough data there to get a feel for it. We did that for the first 2 platforms at the level of 500. Just due to time and cost, we reduced it by half to 250 for the remaining 5 platforms. All of that data was done by selecting it from the data we already had that came from June 2025 up until the end of last month, end of the month before. End of the month before, we're now in July. Staff checked the items, found good examples that represented each of the subtypes, filled in the slots, so we had the right number of examples for each subtype, and then we've selected one item from each platform for each category to put into the report itself as an example. So there's a lot more data that is in these appendices. I suspect that's why I have 2 folders here. I think someone's printed them all out.
Thank you. And just to clarify a few aspects of that methodology, for the sake of clarity, the examples that are maintained by OHPI are divided into 27 subcategories. Is that correct?
27 subcategories, and those are subcategories of one of 4 sort of major categories. And items can be in more than one subcategory and therefore more than one major category.
Certainly. And the 4 main categories are Holocaust-related material, incitement to violence, traditional anti-Semitism, and Israel-related anti-Semitism. Is that correct?
That's correct. I will clarify that the incitement to violence, it could be violence. It does also include, for example, property damage, incitement to, attack synagogues, etc. So there's levels of harm there that may fall short of actual violence to people, but it's still in that sort of general category. And the last category, traditionally we've called it Israel-related, but increasingly since October 7, 2023, it's Israel/Israeli/Zionist/Zionism related, just as a general category.
Certainly. And you gave evidence on the last occasion that for each category except the Holocaust jokes category,
Yes.
The parameters within which content is allocated to the category are aligned, or at least linked, to the IRA definition. Is that correct?
Correct. The actual categories were made, the 2 IRA definitions.
Yes.
So the actual categories were made by the Australian experts to IRA at an IRA meeting overseas, taking the 2 definitions, going through them and effectively saying, okay, this line will be category 1, this example will be category 2, these few words will be category 3. So it's all directly linked back to the text in either the IRA working definition of Holocaust denial and distortion, which was the first one, or the IRA working definition of anti-Semitism, which was the second one IRA passed.
And in terms of that exercise that you just described regarding the formulation of the specific categories into which content is allocated, could you just elaborate a little on the process that was followed to reach those parameters?
The IRA experts, there were 7 of us. I believe we were all there. I believe it was the plenary in Rome. We sat around a table with the 2 definitions and literally went through them line by line, working out, does this line give us something new, in which case we add an extra category, or have we already covered it, in which case we can just move on to the next bit of the text. So it is derived directly from the text. We started with the 26 categories directly derived, and we added the Holocaust jokes when we found that they really didn't fit anywhere else and needed their own category, because some of the platforms were saying, well, humour is an exception, this should be allowed, even after Holocaust denial was being banned. So we just wanted to be able to count that separately and be able to easily pull that data out.
In applying the IRA definition in respect of anti-Israel anti-Semitism, do you take regard of context?
Yes, the IRA definition itself does require that context be taken account of. There are categories, even in compiling the data for the Commission, there's things there where we say, this feels wrong, this looks highly problematic, but we wouldn't call it anti-Semitism. We'd say it's something else wrong with it, but not necessarily that. There's also very peculiar cases, not so much on the Israel ones, but with some of the Holocaust-related ones, a Nazi swastika, and even our local neo-Nazi groups are not always behaving in an anti-Semitic manner. So a swastika and a neo-Nazi who is, for example, engaging in transphobia is not engaging in anti-Semitism at that point in time. Even though the ideology is anti-Semitic, when you take into account the context, they're actually doing something different in that instance.
And I'll come to the detail of the process by which these pieces of content are recorded, but is one of the functions of selecting the 27 categories and coding by reference to multiple categories that in the ultimate data, the individual instances can be aggregated and disaggregated down to the individual category level?
Yeah, correct, to the individual category, and also we don't actually code under the major categories. What we do is then analyse the data and say anything that is coded under one or more subcategories that belong to a major category count once under that higher level category.
Yes, and so as a consequence of that, the data, to the extent that one wished to exclude a particular subcategory, can be recut in order to exclude that subcategory from the broader data set. Is that right?
Correct. So one of the bits of analysis we do, and I don't recall at the top of my... Oh no, it was in the first report. There was a table. We looked at how many of the items that were in Category 4, and particularly in the Category 4 item that refers to denying Israel's right to exist by saying it's a racist endeavour, how many items that fell within that category were not in another category as well. So how many of them were only in our sample because they fell into that category? And the answer was startlingly small. It was like a handful. And that can happen for two reasons. One is because a particular statement might fall into two. So if you said, Israel is a racist endeavour and we don't know about it because of Israel's control of the media, and it has no right to exist, and therefore we should support efforts to eliminate it, it's going to fall under both the control of media category, and it's going to fall under, I think it's 4.2, which is the Israel has no right to exist category, and it will also fall under 4.4, which is traditional anti-Semitism, in this case the media category, but being applied to Israel.
Certainly. And in your first statement, you gave some evidence about the cycles that you described earlier being an 8-cycle exercise.
Yes.
Could you speak a little about why the process is designed by reference to hourly collection points?
Yes. Firstly, I'll start off by saying the 8 hours, as I mentioned last time, is just because that's a standard workday of 8 hours was how we came to that. Our initial collection after October 7, we actually did 16 hours, but we did it over a few months rather than all in 1 month. So that's the 8 hours. The reason for the 1 hour periods, firstly, for any given platform, it spreads it out across the month. It also divides it up. We have 2 analysts that actually do the collection. So we have 2 different people exercising human judgment on half the sample each. So that helps avoid any sort of biases or problems. But also with 4 cycles for each of them, they're spreading it over the 4 weeks of the month usually. And because they're going through all the platforms before returning to the first one again, when they start again, time has moved on. They're starting with a new search, and it means if there was anything that was biasing their initial search, they picked up an item that, for example, happened to belong to a particular extremist group or something, the other 7 samples are unlikely to be in the same sort of echo chamber. So it means across the 8 samples, we should get a good representation.
Thank you. And so in terms of the searching exercise, can I just confirm a few details with you? As I understand it, the coders apply an updated list of search terms to identify content in the first instance, is that right?
That is correct, yeah.
And when they find the content, they fill out a uniform data capture form that records certain details, is that right?
That is correct, yeah.
And they include the URL of the content, the URL of the user, uploads of the screen capture or video, and the category of online content against which the content is being coded. Is that correct?
That's correct. There's a few other fields there that are mentioned in the report. We do have a field, for example, for comments. Again, going to Your Honour's comment about context. If there is something there where the context is important and they see the context, they can actually put in a comment so that we don't lose that information. There's also a flag if the person looking at it thinks it's an inauthentic account. So, for example, a bot or something like that, they can flag that as well. We do also actually have flags when they first capture it. There's a general flag to say it's anti-Semitic, but something can be anti-Semitic and be against another group. So we also have a flag for Islamophobia, for anti-LGBTIQ+, for misogyny. So if it hits multiple categories, we will capture that as well. And just in the case of Islamophobia, we also have other subcategories. So in that case, it would come up first to code it with the anti-Semitism ones, and then to code it into a specific form of Islamophobia.
Certainly. And in terms of the other types of information that are collected, if there's a clear geographical nexus apparent from the piece of content, is that recorded as well?
Correct. So we also do, we get them to look at the profile of the person that posted it. If it's clear from the profile where the person's from, at the top level we have a couple of very broad geographic regions. So for example, North America, Europe, etc. Australia obviously is its own one because that's particularly significant for us. So they flag it with that, but then there's another field where if there is a specific location, they can put it in, and that could be a particular city, whether in Australia or overseas. It can get very specific. That information either comes from the profile itself, that the person says this is where I am, or from the context of their content. So it might be that their post is filled with AFL content and we say, okay, this person looks Australian, okay, or it's filled with Australian news commentary and things and we say, yes, this looks Australian. It's not guaranteed to be perfect, but it's a pretty good guide.
And your standard practice is at the point, or the standard practice that's followed is at the point that the content is recorded, it is also reported to the relevant platform, is that correct?
Correct. The last step is to report it to the platform itself using their internal processes. And I'll just add, in the case of the data given to the Royal Commission, we went back and re-reported everything last month. So it's all been reported at least twice by us.
Thank you. And that you said the last step in the process is reporting.
Yes.
After that point, the content is submitted to the system, is that correct?
I would say it's usually, well, it could be. I would say it's probably submitted to our system first before they report it, and then they move on to the next item.
And at that point, there's a time and date stamp recorded on the submission, is that correct?
Correct, yes.
And so it follows from that, does it, that the time and date stamp is relatively contemporaneous to the report to the particular platform in your data?
Yeah, give or take a minute or so, yes.
And the staff who undertake this data capturing and entry work, they're trained for at least 3 months on technical aspects of the work and definitions of anti-Semitism, is that right?
That's correct, yeah.
And testing is also conducted on the human coders by having them categorise the same data as each other and then cross-referencing the results, is that correct?
Yes, and we're currently training up new analysts to be able to do that work as well.
Thank you. Now, turning to the exercise that you've performed for the Commission, you've provided the Commission with a series of attachments to your report that contain the anti-Semitic examples of anti-Semitic content that we referred to before, that's correct?
Yes, and that's why it's so huge.
And
it's literally thousands of examples we've given, and I've got to say for the Commissioner and others that will be looking at this, it is quite intense, and we have had a challenge for the team because we've looked at a lot more content in a shorter period of time than we normally would. So it does have an impact.
And before you referred to slightly different numbers of pieces of content, it was 500 each for X and Meta and 250 Correct. For the other platforms?
Yeah, and though that's the, that was the target, the actual number will be a bit higher because, as I mentioned, some of those on that sample size, it would say we need 1 example or 2 examples, and we've tried to increase those to a minimum of 6. There's a few categories where on some platforms there just wasn't any data on that category. It's a very small sample, but in general I would say we have at least 500, probably a few more, and at least 250, probably a few more.
Now, you've also provided, in addition to the attachments to your statement, an appendix with some examples to just give a flavour of the content as part of your statement, is that correct?
That's correct, and those examples that are in the statement all come from that sample, so there are IDs there that cross-reference them.
To the broader data set?
To the broader data set. There are additional examples in my statement that are not part of that data set. So, for example, there was a collection of data after the Bondi attack that we provided to Meta, and that they've then re-reviewed. So we checked how many of those are still online and provided that data as well. So there's another sample of, I forget how many hundred, but it's in the report.
Thank you. Now, I might just bring up an example to illustrate this point. So if I could ask the operator to turn up stat.8.999.0407.030, which is an example that's been taken from your appendix. Sorry, it should be 0030. So focusing on the piece of content at the top of the screen here, do I take it from your explanation before that this would have been screenshotted by one of the coders?
Correct.
And then the material extracted from the spreadsheet at the bottom is indicating that it was displayed on X, observed on the 14th of April 2026 at 9:20 a.m. and 28 seconds, and then removed by the 11th of June. Is that right?
Yes, I'll just clarify that removed by, it may have been removed, as soon as the 14th of April. We knew it was there on the 14th of April. We can't tell when it was removed between then and when we saw it was removed on the 11th of June. So it doesn't mean it took that long, but somewhere in that period, when we rechecked it, this content was no longer there.
And that's a function of X not making that type of information available to the public, isn't it?
There may be an email that the analyst that first reported it would have got, but we're reporting literally thousands of these things and trying to marry those communications back up without a dashboard, which X doesn't provide. It'd be very hard. If there was a reason to do it for one or two examples, we could probably put in the effort, but we're talking hours worth of work to trace one item.
And some platforms don't.
Some platforms provide absolutely no information, even whether they've actioned the report or not.
Now, if I could turn to the next topic, which is concerns your evidence regarding platform responsiveness. As the head of an organisation that systematically reports anti-Semitic material to platforms, have you made any observations about the prevalence of content in general on the platforms?
Yes, so we, as I showed last time, we have graphs showing the different levels of anti-Semitism on each platform overall, but then we can break that down into the four major categories. So for each of the platforms we've looked at in the report, what I've provided, I don't know if you want to pull one up, I provided a graph showing for each sample of data we've collected, so for each 8 hours once a month since June, and at various periods before that, what is the number of items we were getting in each category at that point in time. And by plotting it over time, we can actually see a graph of the levels rising and falling. And we can see different patterns on different platforms.
Yes, and we might come back to some of the aggregate level reporting at a later stage, but if I could perhaps to your invitation take you to underscore 0034 of your report. Sorry, this is I should give the operator the proper document ID, stat.8.999.0405_0034. So is this the platform specific aggregate anti-Semitism
this
data?
is the platform data for Facebook specifically. The first thing we've got is the total number of items collected in those 8 hours in each period. And again, for some of them, we've scaled down to 8 hours in order to make it consistent. But yeah, you can see how over time, the level that it rose to, I mentioned before, the sharp rise after October 7. On Facebook, that just became the new normal. And there's a number of points, I'll point to particularly January this year and April this year, which are actually significantly above even what we saw after October 7. So that's a problem. If we look then at the bottom graph, that's showing that same data but broken down into the 4 different types. So what we can actually see there is a rise across multiple categories that lead to that result. So you can see the spike in April. In fact, every single category went up that month, and that in aggregate leads to the total rise we see in the graph above.
And could you just give us a flavour of what's captured within the traditional anti-Semitism category?
Yeah, so I don't know if you want to pull up the schema, but in general terms, it covers a range of specific traditional anti-Semitic means. So, for example, global Jewish conspiracy, Jews control the banks, Jews control government and government institutions, Jews control the media. It also includes a generic traditional anti-Semitism category, which covers things like blood libel, things like diocide. I think we've got one in there also. I think the dual loyalty one may be in there, or maybe in category 4. I'd have to check. So yeah, there's a list that covers them. 3.6 is the most generic one that also captures things like racial slurs and those sorts of forms as well.
Dr Oboler, do you have an opinion about a causal link to the high figure in April of this year?
I believe what we're seeing is a result of the Iran situation. So there is a tie-in to events overseas. I believe other witnesses have mentioned that as well. Although that's not always the case. Some of what we're seeing in our data, particularly when we break it down, sometimes we see one form of anti-Semitism increasing when others on the same platform are not increasing, which could indicate that there's some sort of campaign or activism or something that is pushing it up from a particular community of anti-Semites, if I can...
On the graph we saw a moment ago, it looked to me as though the graph for the anti-Israel anti-Semitism roughly followed the graph for the traditional anti-Semitism. Does that suggest that frequently elements of both were present, or is it...
Not necessarily. There is some relationship, because some of the Israel-related anti-Semitism, particularly category 4.4, which is traditional anti-Semitism applied to Israel or Zionists, it could be coded as both whatever form of traditional anti-Semitism it is, and also in category 4.4 as Israel-related. So that will be the same data item actually rising both of them at the same time. But it's also possible, so there's a certain percent of that, but in this particular case in April, we're also seeing Holocaust-related content rise, we're also seeing violence-related content rise. So I would say while there is some overlap, it's more of, everything is rising.
Now, Dr. Oboler, in your report, you've made some observations for a number of platforms, both with respect to the trends in the content on the platform and their responsiveness to reports. I was just going to take you through each platform and give you an opportunity to elaborate on those observations. So if we could start with X-Corp, what are your observations about the prevalence of anti-Semitic content on that platform and their responsiveness?
I might get you to actually give me the paragraph number if I can jump to it.
Certainly.
Just so I've got the graphs in front of me.
I don't think we need to turn up the page, but the discussion of X-Corp starts at _0084 using the Bates numbering at the top right-hand corner of the page.
Mine doesn't actually have that numbering at the top right-hand corner. Sorry, I'll find it.
That's fine.
Sorry, page
29. We could do 29. Paragraph 29.
Nine of the second report,
great.
I have
Thank
reference to
Yes.
X.
Okay, thank you.
Thank you, Commissioner.
Oh, yeah, this is just the,
This is the executive summary.
this is the
Yes.
executive
Yes.
summary,
Yes,
yeah.
that's a convenient place to start.
Yeah. So my summary on X was generally it's difficult to work with, particularly from Australia. And I have shared in the detail of the report a significant difference between what I've seen in Australia compared to what I've seen in Europe, where X, because there was much more regulation, I attended a meeting with the trusted flaggers in Europe, with the European Commission. X had more staff in the room than any other platform. And effectively had a staff member assigned to each of the people doing the monitoring so that they could have a concierge service to deal with whatever they found. But, you know, the example I give there, it's like we've got a temperature control on the wall, and rather than fixing the temperature, what they're doing is tampering with the monitoring device. Okay, because if you remove the stuff that's the only thing being monitored publicly, you can reduce the level, but it doesn't change the real situation. It just changes the situation on what's being monitored. But as I say, they had a lot more staff there, whereas in Australia, it's been quite a few years since we were able to actually have contact with them. So I believe the current e-safety commissioner was the last Australian-based staff member at Twitter that I was able to engage with. We have had engagement with them back to head office since then. But that was coincidence that one of their senior legal people happened to be someone I studied with here in Australia, who went on to work for them.
And were there any particular events involving Twitter or X that precipitated that change in approach?
Well, a number of things changed. The largest one, obviously, was Elon Musk buying the platform and changing it from Twitter to X. Which led to about 80% of the trust and safety staff being fired almost immediately. So there was a major change in that regard, but also a philosophical change where it went from a platform that was at least trying to improve safety to a platform that said, no, we believe absolute free speech almost. Not quite that far, but certainly we believe there should be more speech and less limitations, and a lot of people that had been removed from the platform prior to that were invited back onto it. A lot of people that had been causing problems came back in, and the environment just became more and more toxic. I will say that we see, I know others have brought this up, I believe so, Elon Musk himself has amplified certain content that, really promotes anti-Semitism and pushes hate. And obviously we saw it after Trump's election, we saw the Nazi salute that he did at the event. So, read it as you will, but there's certainly a problem there that is being amplified and coming from someone with a huge degree of influence over the platform.
And you yourself have been the subject of anti-Semitic content on X, is that correct?
That is correct. After I testified in the European Parliament, within an hour or so, there was a post made on the platform that took a video I'd made for the Swedish government for an anti-Semitism conference, the Malmo Forum, took my video from the Swedish government's YouTube channel, superimposed Nazi symbols onto my image, altered the video, and then reshared that, and that came from an Australian user. I did report it to the platform and it did get removed through the regular reporting. I did also email the representative of the company who had been in those hearings, and it took, the content was removed within about a day, but it took many days before I got a response back from the staff member, which again shows that gap in responsiveness of the platform.
Certainly, and I might just go to that piece of content. So if I could ask the operator to call up stat.8.9.00001.0405_0085.
Yeah, and this will bring up an image. The Commission has also been provided with the video.
And so that's the video of you that was promulgated with those symbols after you'd given evidence to the European Parliament, is that right?
Correct. Within about an hour, and that the account this is from, as I say, is an Australian account. And when I checked it a few days ago, this account was still online.
And the inference that you're drawing there is that because Aussie appears in the handle at the top of the account, that it's an Australian account, is that right?
Yes, and I've redacted part of the name, but yes, it's an Australian account.
And I might just take you back over to the previous page, paragraph 99 of your statement, where you describe your own personal experience of reporting the content.
Yeah.
Paragraph 99 on page _0084.
Yep.
And at the bottom of that paragraph, in the penultimate sentence, the email to the Twitter representative that you'd met in France took more than 15 days to get a reply. Is that
That's right? Correct, and my email and their reply are also included in an appendix.
Yes. And going back to page _0081, you provide some information about the trends in anti-Semitism on X over time. I might ask the operator to go to page _0081.
I think it's 82.
81. On my page.
Yeah.
You and I, Doctor, don't have the ID numbers.
Right.
But this is the
Yes.
the relevant page.
Yes. Yeah, so what's interesting here is, contrary to what we saw before, you can see in the most recent, April to May, traditional anti-Semitism went up while the Israel/Zionist related anti-Semitism went down, and we can see the same thing happened in August. The way I would describe this is to say that on X there are multiple different communities sharing anti-Semitism that have got very little to do with each other, and one goes up and another goes down, and there is no relationship between them. And this is what you get with a platform that is allowing, an anything goes sort of attitude.
Now, I don't propose to go to the detail necessarily of each individual platform's trends, but I did want to take you through each platform just to get your observations. The first platform after X that I wanted to take you to was Telegram, which commences at paragraph 80 of your statement. Do you have any observations about Telegram's anti-Semitism prevalence or responsiveness at a general level?
Yeah. So, firstly, I've got to say, and it may be worth pulling up that graph actually. Telegram is a platform where most of the data we're gathering is coming from the far right. That symbolises a large part of the audience there, but it also symbolises the particular content we seem to capture on it. The level has increased after October 7 and remained high, but other than in October 2025, the level there is a little bit lower, or lately in April at the same level as after October 7. It's not growing the same way we saw on Facebook. But what's really interesting is when we look at the 4 different flavours, it's very clear that traditional anti-Semitism is most of it. It's the graph up the top and everything else is way lower down.
Yes, and that's at 0070. If I could ask the operator to call up that graph. So what you're referring to in that example is the high black line for traditional anti-Semitism in the bottom graph relative to the other forms.
Yeah, and that's showing that what we have is not really a mix of different types so much. We really have a dominant strand, and I'd say this is the only platform where it's really so clear that it's one type of anti-Semitism and one sort of source of anti-Semitism that is dominating.
And you've observed elsewhere in your evidence that there's also evidence of channels on Telegram that are linked to Iran serving as a resource for anti-Semitic content that is then shared across other platforms.
Yeah, one of the channels we came across, some of its content was promoting the Iranian Revolutionary Guard Corps. Other content was just a whole lot of different forms of anti-Semitism being shared as a resource for people to further share. So, this was, basically a pool of content for their supporters to draw upon.
And the next platform that I just wanted to touch on is Reddit. Could you provide any general observations about Reddit?
Yeah. So I'll try and find the.
Is there a paragraph
It
number?
starts at 73 with the
Oh.
trends. Paragraph 73.
Yeah. So before I get to the graphs, I'll just say Reddit is different to the other platforms. There's been some changes literally in the last few weeks. Reddit is different in that it tries to push the moderation onto community moderators rather than sort of professional staff that are doing trust and safety. They do have professional staff as well, but they're trying to really reduce what those people do and rather have decisions made by the community itself. This does create a problem because where anti-Semitism is harder to understand or changing its nature and you need to retrain and educate people, doing that with a really large pool of volunteers is a much harder challenge than doing it where you've got paid staff where you can implement training, etc., and have them follow it. So that's the first challenge. Reddit is up and down over time, but for this year so far, what we're seeing is a general rise in both traditional anti-Semitism and that Israel/Zionist related anti-Semitism. And at the current rate, in another couple of months, it's possible that those two either converge or even that the Israel/Zionist related content may surpass the traditional content. It's growing faster. That to me speaks of an inability to recognise it. Clearly there was something that happened around October, November, where it takes a dive. That's the blue graph at the bottom. And that's clearly a recognition of a problem and a response. And there were, I forget the exact timing, that's probably it actually, but there was some intervention on Reddit, particularly from the Anti-Defamation League, and there were efforts to reach out to them and respond. And this is not the only platform where we see that they get bad publicity. An organisation works with them to try and fix the problem. We see a correction, and then over time we slowly start seeing the problem rise again.
Would another possible explanation include that in October of 2025 there was the ceasefire in Gaza?
That would affect it as well, yes. The traditional one is still pretty much level. So I would say yes, the lack of energy, if you like, in pro-Palestinian activities. Again, I'm not saying that all those activities are anti-Semitic, far from it, but there is a segment of anti-Semitism that goes on the bandwagon with that.
Yes.
And when there's less activism, there's therefore obviously less opportunity for that anti-Semitism to rise. So yeah, that shows it too, but it's interesting that we don't see the same dive in some of the other categories. We see them reduce a little bit, but not as much, which again suggests that it really is a certain group that was pushing a particular flavour of anti-Semitism that suddenly cooled down.
But just to test that a little bit, the correlation point, there hasn't been any regression analysis or anything of that kind to isolate the particular, or attempt to isolate the particular causes, is there? It's really an observational.
It's an observation on the particular flavours and where we know it comes from, and events occurring in the real world that could lead to it.
Certainly.
Yeah.
Now, in relation to TikTok, which starts at 84, could you speak briefly to the trends that you've observed with respect to TikTok, both in terms of content and responsiveness?
Yeah, TikTok, there's There's another graph on TikTok that appears somewhere else. I can't remember where it is. Oh, sorry, no, I'm thinking of something else. It's okay. So TikTok, we can see a rise after October 7. That's actually the third lowest point in our data. So TikTok has grown far beyond, yeah, you can see it there. So it increased after October 7. It dropped a little bit in our next sample, which was over a longer period of time. And then it started rising again, and it's remained particularly high since then with some variations, but we're looking at almost twice the level after October 7. So that's a real issue. And if we look at the bottom graph, we can see that really, again, it's that traditional anti-Semitism. We can see it going up and down a bit, but it's the traditional anti-Semitism really driving that. So there's flavours of traditional anti-Semitism that are not being picked up.
But that is notable about it, because
Yeah.
you indicate October the 7th appears to be the precipitating event for a notable increase,
Yep.
but the increase is in traditional anti-Semitism.
Well, it's in all of them
Yeah.
after October 7, but then that traditional anti-Semitism has continued to grow. And also, if we look at the red line, the Holocaust denial also seems to be, at least since November last year, on a steady rise. Yeah. Now, TikTok has had changes in ownership since October 7. It's moved to being largely US owned now. There's been a range of different changes to the company that have been happening. Now, one of the things we find is that the removal rate when things are reported is actually quite good. So the problem we have is the reliance on people to do the reporting, to capture it, that any sort of automated or proactive work is just not doing the job. And it's being left to the public to report. When they report it, we get a relatively good response, but there just aren't enough people to go out there and clean all this stuff up. The other problem with TikTok is there's content that has a very short lifespan, which means by the time someone can actually report it and do something about it, it's already gone. So you can argue, well, okay, nothing to address now, but it just means another piece of content has replaced it. So the experience can be very anti-Semitic, but every item is resolved before there can be any consequences.
And that reflects the fact that it's a Reels-based,
Correct.
scroll-based platform rather than a static
Correct,
content.
and it's not all the content, but it's certainly some people are deliberately using the Reels format where they can post something problematic, and by the time the system can deal with it, it's not there anymore anyway.
And if I could next go to YouTube, which is at paragraph 101 at _0086. And ask you the same question, both trends in content, but also I'd be very interested in your observations about YouTube's overarching approach to multi-layered content moderation.
Yeah, so firstly, again, we're seeing this general rise where October 7 was a high point, and then that high point's been surpassed as we've had new highs. And again, here we're seeing February and April again. Remember, I think Facebook, it was January, so for some reason there's a bit of a delay when it comes to YouTube. Perhaps that's due to the amount of time it takes to create a video, that some of them put more effort in and took longer. Yeah, it's grown far beyond that. If we move to the next graph down, just the next page, if we can. Yeah. So what this is showing is that the levels are relatively stable except for that traditional anti-Semitism. So again, we're seeing a sharp rise, but I'd note again here, if we look at the last, April to May, we have traditional anti-Semitism rising slightly while Israel/Zionist stuff is dropping. And also if we look at February, we can see a spike in traditional while there's a dip in Israel/Zionist content. Other than those points, there is we can see from October through to December, it's sort of mirroring it, following together. We can see it following together March to April, both were on the rise. but it's not a complete correlation between the two. So part of this, and I think what we're really seeing here is the effort to upload content might be the same, but it's then mitigated by the platform's efforts to remove that content. So even if there is an increase in what people are trying to post, if the platform has a good way of detecting and removing something, it may not actually come through. By the time we look for it, it's no longer there. So I think that's part of what we're seeing in the differences here.
But pardon me, Doctor, wouldn't you expect that traditional anti-Semitism would be the most readily observable by people monitoring for the platform?
You would hope so, but the data's not showing that. It's showing a larger and larger gap. And the way I would explain that is a lot of this traditional anti-Semitism is being included in political content, and some of the platforms are having a problem, and we've heard this argument in Australia that it's not anti-Semitic because it's political. Now, racism, I believe I said this last time, racism is always political, almost always political. So if we were to exclude any form of racism when it's political, we're saying, the White Australia policy was not racist, it was a political policy. We're saying Nazism was not racist because it was literally a political policy of a party and then a state. So that logic really is flawed. The first question is not whether it's political, the first question is whether it's racist. If it is racist, that's it. We don't need to consider whether it's political. So yeah, I think what we're seeing here is an inability to enforce the rules rather than an inability necessarily to get the rules right.
But your organisation itself meets with Google on a monthly basis, is that correct? And you've also referred to them having a multi-layered approach to content moderation as well?
Yeah, sorry. And so I'll backtrack a little bit just to say I've described it in detail in YouTube, but there is a similar approach on a couple of the other platforms.
Yes.
This is an approach that, to my knowledge, was actually first implemented by Meta. They brought in automated approaches to proactively remove content, and for a number of years we're very proud of getting 90-something% of all of the hate speech removed automatically before anyone saw it. And the problem is, in January last year they got rid of that. So YouTube is still doing it, and YouTube describes their process very well. What they do is, when content is put in, and they made clear that this is both videos and comments, it's all assessed automatically, and if it is deemed clearly to be hate speech or another policy violation, the content does not go up. If it is highly likely to be a violation of policy, but the system is not completely sure or not to a sufficient degree, then it gets queued for human moderation. So it might go up, but it's going to get looked at before a member of the public has to actually report it. It's already in the queue.
And why is that layer of human content moderation at the end significant?
Well, firstly, because we don't want automated approaches, we don't want to have such a low threshold for the automated approaches that they interfere with free speech, that they're getting it wrong too often. So instead what we do is we set a very high bar for automated approaches. So only when it's stuff, if it's a comment that says kill the Jews, and that's the entire comment, we don't really need to consider context too much. Okay, and that can be something that's automatically removed. If it's something where we may need to consider the context, or where it's possible that 90% of the time it would be removed, but 10% of the time it wouldn't, it needs a human to actually look at it. So that's when it gets queued and it goes for a human review. After it's up, the next step is that a member of the public can report it. And if a member of the public reports it, then it goes into the queue to be reviewed by a human. And this could be because the AI didn't flag it at all and said this is fine, and a person's now picked up something that the AI couldn't. So it goes in for its first human review. Or it could be that the system flagged it as possibly hate, a human reviewer looked at it and let it slide, and now a member of the public's flagged it, and a different reviewer will look at it and may reach a different conclusion.
And what are the difficulties with just relying on flagging as a mechanism of regulating the content?
Yeah, so the first problem is scale. There's simply not going to be enough effort to flag all the content, and we see this with the massive drop in removals by Meta that we've seen from their own transparency data. The other thing is that it actually puts a burden on the communities that are being subjected to this hate. So it's really putting it on them to see all the content, be impacted by it, and then have to respond. It's a similar problem. I know there's been comments in the media now from some of our politicians to say there should be, criminal charges for hate speech, which was originally the intention. It was just that when the Racial Discrimination Act went through the Senate, they blocked those. The reason for having criminal sanctions is because it shifts the burden from the individual having to take it through the process to the state. So this is the same thing. Having an automated approach shifts the burden from the impacted community and the public to the platform to reduce the harm before it causes an impact rather than after.
So instead of charities and community groups like yours doing the heavy lifting, the responsibility is on platform design.
Yeah, and I mentioned last time I appeared, our job is not to try and find and report all of the hate speech. That is simply impossible. Where we would like to be is in a position where all of the easy stuff the platforms have already dealt with, and it's not even there for us to look at. I know another witness earlier this week spoke about clusters. Our view is that's not the right approach. The clusters are things that the platforms should be able to identify and deal with themselves, right? If you can identify a particular narrative or set of keywords or discourse, recognize it, it should be possible to automate the removal of that content. The job of civil society organisations and experts is firstly to find new trends when the language of racism changes, when hate's expressed in new ways or in new mediums, but also to find the gaps where platforms are not identifying something that their policies should cover, but their understanding, the training for their staff just isn't picking it up. So if I give an example, the first one we had was Holocaust denial. I think I may have mentioned this before, where it was that discussion with a German journalist that I said, do Holocaust denial, it will be the easiest one for you to report to your audience if you want to talk about online hate on Facebook, only for Facebook to turn around and say, no, actually, that's not against our policies. So we accidentally found a gap. Later, we found another gap with the Protocols of the Elders of Zion, where the full text was available in multiple places on Facebook. And the company's initial response was, well, it's a book. You can buy the book online. You can download it for free. Why shouldn't we have it? And we had to explain to them that this is a core anti-Semitic text that drives up anti-Semitism, but also because of the nature of your platform, what you're doing is you're allowing it to go viral, which a book itself doesn't do.
But with respect to the platforms, while community groups obviously play a vital role because they're the most proximate to the harms of the speech, you would agree that the platform has a role in shaping the experience for its entire user base, would you?
It does. Look, I give an analogy here across all these platforms. So the internet was referred to as the information superhighway. That was one of the first descriptors of it. Now, if we think of it as a physical highway, what we have is virtual monopolies with different platforms owning different stretches of this highway and making up their own rules. Some of them may have a speed limit, others may not. Some may require driving licenses, others may not. Some may require seatbelts, others may not. So the first problem we have is each of these platforms has different safety standards, but also, in general, the safety standard is pretty low. And if we report, again, going to Meta, their transparency report is talking about a prevalence rate based on views rather than based on content of 0.01%. That's suggesting, 1 in 10,000? but it's 1 in 10,000 views. Now, if we were to use that traffic analogy and we were to say that, well, we're going to measure it based on metres travelled. So we're going to have an incident for every 1 in every 10,000 metres a person travels, right? And you consider how many metres a person travels, then multiply that by the population that's travelling, you're actually talking a huge volume of incidents. And it's just the way it's reported that makes it look low. So, you know, these are the problems we're facing, that it's just the expectation is not meeting what the public expects.
And if I could just come to the last two platforms.
Just before you do, Mr. Sherman, can I ask this? Taking you back to your YouTube graph, am I right in thinking, again you see the pattern that October the 7th, 2023 caused a spike?
Yep.
But the most notable spike is in traditional anti-Semitism. And if you were to say that there appears to be a causal association between events in the Middle East and rises in anti-Semitism, rises and lows depending on what's happening. Again, though, looking at YouTube, whilst that may be the causal event, the consequence is traditional anti-Semitism.
The consequence
as the greatest.
Yeah, the consequence is traditional anti-Semitism, but also I don't think this graph, particularly the traditional anti-Semitism, really mirrors events in the Middle East. You know, it's. I wouldn't say the events in the Middle East have continued to get more and more and more intense. Slowed down in January. You know, we did see the Iran stuff, but I'm not sure that it directly mirrors the dates we're seeing there. So I think what we're seeing is a failure of the systems because YouTube does have automated systems.
Yes.
I think we're seeing a failure of the automated systems to capture the current ways this anti-Semitism is manifesting.
I suppose what I'm just taking up with you is, so far in all the graphs,
Traditional
there is a spike from
Traditional.
about 9 October 2023, 7 October 2023.
Correct. What's really interesting, I think we'll go to LinkedIn next, the last two.
We're going to go to Meta and then LinkedIn. Yes.
Yeah. Okay.
But I can go to LinkedIn if that would help.
Yeah, I think it's interesting on this point.
Paragraph 48 on underscore 0048.
So LinkedIn is interesting, firstly, because the spike, right, the two main spikes we see are after October 7, remembering for LinkedIn we don't have data from before October 7. But it's the spike after October 7 and then on the anniversary. And the other thing we see is this is the only platform where that Israel/Zionist related anti-Semitism is actually the dominant form. So there's you can still see the same sort of thing with the traditional anti-Semitism, but it's overtaken by the blue there, which is that Israel-Zionist content. And what that's really saying to us is that there is, because LinkedIn also has very good proactive systems, and generally the level on LinkedIn is lower than other platforms.
Yeah.
So it has a gap, it has a blind spot. And when we look at some of the other platforms where they put out statements, recognising that the word Zionist is sometimes used to express anti-Semitism, LinkedIn has not made such a statement. And in the response to the Commission, LinkedIn says, well, the data we have is reflecting a different understanding of anti-Semitism that doesn't reflect their understanding.
And so is the point there that unlike organisations like Meta and Google who have statements about that particular issue, Microsoft hasn't taken the step of doing that?
Correct. They haven't recognised this particular flavour of anti-Semitism, and I would even go a step further from their statements. Other platforms, and YouTube did this very well, as did Meta, recognise that the nature of anti-Semitism and all hate speech changes over time. And it requires constantly updating both the automated systems and the training for staff. LinkedIn basically said, we have a very good system, our system works. If the data is showing a problem on our system, that's a problem with your data. And given it's the same methodology and it's done on all the other platforms, 9 other platforms, and we're not seeing the same pattern on any of the other platforms, I would say the research is actually pretty robust, and the issue is this platform.
And is another aspect of it that most of the users on LinkedIn are professional people, and one might expect fewer neo-Nazis on LinkedIn than on Telegram.
You
Is
would,
that
yes.
fair generalisation?
You would, but there's another side to it as well, which is that there is, firstly, LinkedIn, they're all global platforms,
Yeah.
but in some parts of the world, being anti-Semitic when you're looking for jobs is not necessarily a bad thing. Okay, and even in Australia, in some sectors, as I'm sure the Commission's heard in various sectors in Australia, there is, it's very hostile towards Jews. So someone working in that sector who's pushing pro-Palestinian advocacy, fine. Pro-Palestinian advocacy with anti-Semitism, some people will not care about the anti-Semitism. So that content can make it onto the platform as part of that sort of advocacy, and even for people whose job is working in advocacy. People who work for NGOs, people who work for, in the arts sector, etc., or for universities, who may work in this sort of space and may professionally put stuff onto LinkedIn that does cross the line. And there's certainly examples in our data that show this.
That's what I was coming to. You and LinkedIn are at odds, but your response is to say you can look and see the nature of the anti-Israel, anti-Semitism that we count as distinct from political speech.
Correct, and I think LinkedIn is dismissing it as political speech without recognising that it's crossed that line.
I might just deal briefly with Meta before we break in a few minutes, which starts at paragraph 33. Now, in your statement, you've given some evidence about your organisation being a member of their Combating Hate Speech Advisory Group, but not a trusted partner. Could you speak a little about your engagements with Meta as an organisation and this data?
So there is this Combating Hate Speech group in Australia. It's made up of some academics and the rest are civil society organisations from, across a whole range of different areas of hate speech. I don't think it's appropriate that I name the other groups. I don't think there is a public list, but they do cover experts in a whole range of different topics, ranging from the LGBTIQ plus community through to cyberbullying of young people, a whole lot of different areas. So that group meets, at the moment it's twice a year. My recollection is we used to meet 4 times a year. I could be wrong on that, but that's my feeling on it. We seem to have decreased a bit. That group meets and Meta's very particular in its responses. So Facebook Australia, which is the Australian arm of Meta, runs this group, brings the group together, and when we meet, very often they'll bring in people from Meta Platforms Incorporated, so the US entity, the people that actually make the policies, that enforce the policies. They will consult with us on upcoming changes or ideas for new policies or new features. A number of the partners have also engaged in projects with Meta. So both us and Meta in their response mentioned the work we did during COVID looking at anti-Asian racism. So it's really a partnership where the civil society partners, including academics, and Meta come together to look at what is the current state, what are the current risks, what are the current changes. That differs from their Trusted Flaggers, Trusted Partners program. which is internationally based, which is directly with the global company rather than a particular regional company. They have, I believe, tools that let them report things directly, whereas when we report things to Meta, we literally send emails or phone calls to the Meta staff in Australia, and they put it into the system rather than us putting it in directly. But my understanding, both verbally from staff and again on the papers from them, are that whether you're a trusted flag or whether you're a partner like us, it all gets treated the same way once it's in the system.
Is that a convenient moment, Commissioner?
Yes, it is. We'll take the morning adjournment now.
Thank you.
Dr Oboler, just want to touch on a couple of final topics before you conclude your evidence. One of those topics is the topic of removal rates. And so if I could ask the operator to call up underscore 0101, paragraph 127 of your report. I think you gave some evidence earlier about how at the point that each item of content is logged, it's reported, but that as part of the process of preparing your evidence this time round, there was an exercise that was gone through to re-report everything that had previously been reported. Could you just talk us through how the removal rates in this paragraph were derived?
Yeah, so firstly I'd say these figures do not reflect that re-reporting, so they're before that. We've had staff going through the sample of data we have, item by item, re-reporting it for months now, slowly working their way through, checking, is it still online? Yes, no. If it's still online, let's try again. What you see on the left, if you like, is the number of items that we've checked from each of the platforms, that we've gone and checked if they're still there. And then on the right, we have, of that number of items, what % of them have been removed. And you can see that they vary from 17% on Reddit through to 62% on TikTok.
And one of the topics that you've addressed is the difference between channels of reporting. So for example, in the European Union, where there are trusted flagger provisions, that can represent an effective channel. Is that right?
That's correct. Now, all of this is based on our data. What I will say is some of the Facebook data and YouTube data, not all of it, but some of it may have been shared with the platforms, similar to what we gave the Commission. They get given a list, this is what's still online, and then they would go through it and tell us. And in fact, we did that with X as well many, many years ago, and got back a spreadsheet with reasons why they weren't removing every item they weren't removing.
But as a general proposition, data of that kind isn't available to the general public, is it?
It's not available to the general public. We took a deliberate decision, which differs from, for example, Cyberwell. One of their claims to fame is that they have the world's first open database of anti-Semitism. Our view is that such a database is not a good idea because it allows that content to be recirculated and reused. So we do make our data available with platforms we're cooperating with. We will give them the data from their platform. And where there are things that we believe cross the line that need police attention, we're always happy sharing with law enforcement or e-safety or others in government that can use it. When we share it that way, we give unredacted data, as we've done with the Commission. When we publish things in reports or articles, we always redact. So the idea is the public should not be able to find the content easily if we make it public.
And to that point, we've seen some examples in evidence of particular phrases being adjusted or emojis being used, which might not necessarily reflect particular forms of words. So for example, a juice box emoji or the use of an @ symbol instead of an A. Could you speak to what that might be about?
I can speak at length to that. I won't though. The juice box emoji actually comes from a cartoon called Hipster Hitler. It was a cartoon where they had a young Hitler as an artist, and he wore a shirt that had the juice box. And it's playing on the sound being similar with Jews and juice. So after that cartoon came out, it started to be used by, as code by various anti-Semitic groups, particularly on the far right. But now I'd say it's being used more broadly.
And turning to a final topic, which is generative AI and the risks associated with generative AI. In your report, you've identified a number of distinct risks, including creation risk, transformation risk, and normalization. Could you speak briefly to what those concepts entail?
Yeah, so the creation risk with generative AI is about the ability for the AI to be used to create new anti-Semitic content. And there's details in the report about one particular user we were monitoring who was creating AI-generated anti-Semitic videos at quite a significant scale. And this introduces a number of problems. What the AI is doing is what it does whether it's anti-Semitic or not. It's reducing the cost and effort required to produce content, right? That's its purpose. When it's doing that for anti-Semitic content, what it's doing is allowing someone to upload a volume of new anti-Semitic content very rapidly. And because it's always new content, what it's doing is replacing what was happening before, where someone would build up a bank of examples that they would then keep recycling. And when they're recycling the same content, there's technical solutions that can take a digital fingerprint, recognize duplicate copies and automatically deal with them. When the content is original content every time, which is what this person was doing, it becomes much more expensive to then work out that this is anti-Semitic content and does need to be dealt with. So that's the creation risk. There's another part of that, which is that, as we said, anti-Semitic, context matters, whether it's anti-Semitic. It's possible to generate deeply anti-Semitic images using the generative AI. Firstly, by just building something up step by step, and I had to play with a few of them, and I did this creating an image of blood libel, and following a set of steps step by step, I could get it to create it. If you gave all the instructions at once, then the guardrails would come into play. It's also possible, though, to create an image that is not anti-Semitic until it's used in a particular context. So last time I testified, I spoke about this new trend of kissing the wall. So I was able to take a public figure, ask for a picture of them, then ask for a picture of them kissing the wall, and it generated a picture of this public figure kissing the Western Wall. That could be a real photo, right? As I mentioned, many politicians and others, if they visit Jerusalem, will go and do that. If you then post that into a conversation where the post it's replying to is talking about Jewish power and control of public figures, government, etc., and you post a picture of this, suddenly it's an anti-Semitic image. But there is no way for the AI that's generating the image to know how it's going to be used. So that's the creation risks we face. And the guardrails can prevent some of it, but they're never going to be perfect because of that context issue amongst other issues.
Certainly. Commissioner, I don't have any further questions of this witness.
Mr. Bender.
I would like to give Mr. Evans in writing about the prevalence rate and the violative view rate that are relied on by some of the platforms when they report their enforcement reviews. You understand them to be the headline rates relied on by at least YouTube and Meta in their transparency reports?
Yeah, so Meta uses an adapted version of prevalence, which I've discussed at length isn't the way it's normally calculated. And they commissioned a report early on that told them that if they're going to do that, they also need to provide the number the way everyone else calculates it, and they never have. The violative view rates is a particular metric that YouTube uses. They're the only ones that use that, but it's a similar sort of idea. It's how many items per million, let's say, are a breach of their terms of service, their community standards.
One of your answers this morning was critical of the denominator of the rate, which is the views across the entire platform seen by every person. I want to ask you a few questions about the numerator in the rate, which is what purports to be the amount of violative content that's actually seen. Now, as you understand it, that purports to be what is seen by all users on the platform as a percentage in terms of violative content. Is that right?
Yes, that's the percentage of all the views of content. How many of them, per whatever the denominator is, would be in breach of the rules, in this case in breach of the rules on hate speech.
One of the features of the way in which the major platforms distribute content to their users is the use of a recommender algorithm, correct?
That's correct, yeah.
And the result of that is that the violative views aren't distributed evenly throughout viewers of the platform. They're focused in particular places by the algorithm, is that right?
It can be. They would argue that when content becomes more popular, it's more likely for them to review it and react on it. My concern is that if you focus just on views, one item could have a huge number of views, but a far larger number of items could collectively have more views. Right? So there's an issue versus high viewed items versus the sort of death by 1,000 cuts.
Well, one of the comments you made in your first report is that you concluded that a Jewish person might be more likely
Yes.
to see anti-Semitic conduct that's violating the enforcement rules because they might be more likely to see a Jewish or Israeli post which might have anti-Semitic comments on it. Can you explain how that might arise?
Yeah, so it depends on the platform, but in general, the algorithms that are feeding content to people, right, when they're not directly searching or clicking links, the algorithms that are feeding content to people are trying to give them content that they're most likely to interact with. So for a Jewish person, it's more likely to give them content, firstly, that the people they know, that they're connected with on a platform like Facebook, are interacting with. It's likely to give them content that they spent time looking at in the past. And that means that for a Jewish person, the amount of content that is either reporting on anti-Semitism or is anti-Semitic content that other people reacted negatively to, remember, reactions can be positive or negative, they're still reactions. The more other people in their network do this, the more it's going to appear in their feed. And Facebook in particular, there's a certain share of what you see that comes from different sources. Some of it is based on content you've liked, some of it is based on content that your connections and friends have liked, but it all seems to converge. So I know if I look at my content right now, I would say well more than half of it is either anti-Semitic or about anti-Semitism.
To give a practical example, if somebody I knew on a meta platform saw an anti-Semitic comment on a post about Judaism, and they themselves commented in reply to say, you should take down this comment, it's vile, that might have the effect that the recommender algorithm might be more likely to show similar anti-Semitism to me.
Correct.
Now, is it right that in addition to the algorithm operating in that way, you'd expect it also to be more likely to show anti-Semitic content to people more receptive to it? That is, people more receptive to being anti-Semitic?
I'm not sure if it would show anti-Semitic content more than it would... I'm not sure if it would show anti-Semitic content more to someone who was against anti-Semitism or for anti-Semitism, right? But both of those groups are reacting to the anti-Semitic content, one positively, one negatively. So both of them will be getting that far more than the average user.
So does it follow from that that to the extent that anti-Semitic speech is being shown on these platforms, it will disproportionately be shown to Jewish people who might engage with it or anti-Semitic people who might engage with it?
Yeah, and what it'll be doing is actually clustering it'll be clustering Jewish people and anti-Semitic people together in a sort of public square, if you like, on that content, which is then exposing those Jewish people to much higher levels of anti-Semitism and engagements with anti-Semitic people than would occur for the average person.
And that clustering effect is likely to stimulate more anti-Semitic content, isn't it?
It is.
Now, coming back to the numerator in the prevalence rate or the VVR, none of that at all is displayed within the presentation of those rates, is it?
Sorry, in the presentation
By
of...
Meta and YouTube of the prevalence rate or the VVR. That is, nothing in the rate indicates the portions of the users who are being shown the anti-Semitic content.
So what they do is they show it per views. So you'd need to know what the average number of views a person has are, and the average number of people on the platform, and with a lot of work you can reduce it to something similar to crime rates, and I've done that in an appendix to my first report. but it was a lot of work, and the numbers that come out were over a year, for every 100,000 people, you're getting 200 and something thousand exposures to hate speech.
You certainly couldn't observe from the headline figure, which you've noted is a fraction of 1%, that the people within that fraction of 1% are disproportionately likely to be Jewish or receptive to anti-Semitism, could you?
No, you can't, and one of the big problems with the data is that it stops at hate speech. We don't have disaggregated data for anti-Semitism specifically, and we also don't have disaggregated data, other than YouTube's provided a little bit now to the Commission. We don't have disaggregated data for Australia. So what we're getting is a global level statistic on all forms of hate speech, and some unknown fraction of that is anti-Semitism.
Thank you. Now, would you agree with this proposition, put at a very general level? Somebody who is recommended anti-Semitic content or any hate speech because they are receptive to it, because they like it, would be, one would think, less likely to report it to the platform?
As a general proposition, yes.
Now, doesn't that create an additional problem in terms of the influencer, the recommender algorithm, insofar as it will direct content, in many cases, to people who are less likely to trigger the automated responses necessary for automatic reporting?
The automated responses are completely different to when people report things. So those automatic responses I'm talking about happen when the content is first uploaded, before any user has even seen it.
Now, that's my fault. It's less likely to direct content in many cases to humans who are more likely to report it, because many of the humans who are receiving the recommendations are doing so because they're receptive to the anti-Semitic content.
I'm not sure I would agree with that, because as I was saying before, it may also send that content to people who have been reacting negatively against the anti-Semitic content, who may be more likely to report it. But there is a bigger problem there, which is that because the responses from the platforms to a report, and my report does cover this, generally is rejecting the report. There's only so many times a person is going to report something and have it rejected and be told, no, you're imagining it, it's not really hate, it's not really anti-Semitism, before that person gives up.
I see. So am I right in thinking one of the points that comes out of that is that if all else being equal, a Jewish person is more likely to report anti-Semitic content than somebody who just doesn't care, correct?
They may be, but I would say from talking to people, there's a high degree of fatigue.
Okay.
So there's a lot of content that just isn't being reported because people have just given up and don't see the point anymore. We need to convince them to actually do it, but there needs to be much better messaging and responses from the platforms that take their report seriously, because as long as it's being rejected, the Meta in particular is no longer doing the automated stuff. It's relying on humans to report and then giving them negative feedback, and then they don't report it, and then the stuff just builds and builds.
But even those few who have the stamina to continue to make reports despite having been rejected in the past, what I'm really going to ask you is, do you think that because of Meta's change in January 2025 to the more reactive approach, there will be under-reporting of anti-Semitic content in that sense?
I'm not sure if there'll be less reporting from users than there was, but when you take out the 90-something% that was being dealt with automatically by the platform, there'll be less reports being dealt with overall. As I mentioned before, some of the content the platform removes or used to remove automatically based on AI. The rest of it will get queued, same as if a human had reported it. It will get queued for review by the trust and safety staff. The vast majority of what trust and safety staff would then be looking at, and still look at on a platform like YouTube, is not reported by a person, it's reported by the AI. So the reports that are actually coming from real humans is actually the minority, except I would say when we get to better now, where a lot of that content without the automated reports is purely just left to the users. But the trust and safety team has less content reported, which leads to the ability to reduce the size of the trust and safety team, which leads to less cost. but just leads to less trust and safety.
Thank you. On a different topic, you refer in your written evidence to the YouTube policies of monetising content which came in February 2026 in respect of controversial content. Are you aware of any evidence that hostile or negative content can disproportionately boost engagement by comparison to content that doesn't have those features?
Generally speaking, content that is more emotionally engaging will boost views and retention. So I mean that's a general proposition, and why the platforms end up promoting a lot of negative content. It goes much further and gets more reactions and therefore more revenue than content that is positive or neutral.
In your view, does that create a disincentive on the platforms to invest in self-regulation if doing so would reduce the amount of controversial content that might be seen to earn revenue?
If I can pull the question apart, the revenue is going to the people who, from the platform to the people that make the video. So what we're seeing is both content produced by people for ideological reasons, spreading anti-Semitism and other forms of hate, but also we've seen a spike in content that is purely there to make money. Okay, so you have people that see that there's a market for this content. If they make the content, they'll earn money. So it increases the overall volume of anti-Semitism. I'll repeat something I've shared with my team, which is that at the Online Hate Prevention Institute, we don't usually talk about anti-Semites. We talk about anti-Semitic content, right? So a Holocaust denial video uploaded by someone that is fully convinced the Holocaust happened, but knows if they upload a Holocaust denial video, they'll make money, is still anti-Semitic, right? Even the intent may be purely making money. It may not be an anti-Semitic intent, but the content itself is inherently anti-Semitic. So what we've seen with those policy changes is a rise in that harmful content, both from people wanting to spread hate and from people just wanting to make money and seeing an opportunity.
Taking a step back from the way in which users can make money out of that kind of content, and now focusing on the platforms themselves,
Correct.
And not limiting yourself to YouTube,
Yep.
Is it right that I think what you described as emotionally engaging material is seen to boost engagement and therefore revenue, which could contribute to could contribute to a desire on the part of the platforms not to regulate it as hard?
Yeah, so the platforms would argue that that's not the case. I think it's quite logical that content that is engaging people keeps them on the platform for longer. The longer they stay on the platform, the more ads they see. The more ads they see, the more ads are being sold in order to show it to them. Therefore, the more revenue the company makes. Now, the companies would argue they don't intend to put ads against hateful content, but again and again we see examples of that occurring. I saw one example. We had literally a terrorist manifesto that was calling to kill Jews, and we found a copy of it with Google Ads. It was on a Russian site, Google Ads around it. The ads were from Australian governments. We happened to be testifying in the Victorian Parliament the next day, and they were one of the state governments who were paying for this. But it just shows that link, that it created an opportunity to sell ads, and therefore in this case terrorist content inciting violence against Jews was being used to make money by someone. And in that case the person doing it was a Russian that was exploiting copyright, breaching copyright, but didn't even have a clue what content they were hosting because it had all been automated.
Thank you, Dr. Oboler. Thank you, Commissioner.
Yes. Anything arising, Mr.
No,
Chairman?
Commissioner.
Thank you, Dr. Oboler. You are excused.
Thank you.
Commissioner, the next witness is Professor Terry Flew.
Yes.
Call him to the box, please.
Professor, will you take an oath or make an affirmation?
I'll make an affirmation, thank you.
Yes.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please stand.
I do.
Professor, please state your full name.
My full name is Terry Flew.
You're Professor of Digital Communication and Culture at the Faculty of Arts and Social Sciences at the University of Sydney.
That's correct.
You've prepared a written expert report for the Commission on platform regulation and misinformation.
Yes, that's correct.
It's dated 25th of June and its ID is EX.599.0001.001. And I tender the expert report, Commissioner.
Yes. Yes, well, the expert report will be received in evidence.
Thank you. Professor, can I just spend a moment addressing your qualifications and experience? You did an undergraduate degree in economics and then a master's degree in economics from the University of Sydney.
Correct.
You completed a PhD at Griffith University in 2002.
That's correct.
And
yes.
what was the topic of your PhD?
My PhD was on regulation of broadcast television with particular reference to Australian content standards.
Currently, as I mentioned, you're Professor of Digital Communications and Culture, and your research interests include digital media, platform governance, media economics, and the political economy of global media. Is that right?
That's correct, yes.
You currently hold an Australian Research Council Laureate Fellowship. Could you explain what that involves?
Yes, the Australian Laureate Fellowship is a 5-year fellowship awarded by the ARC. My project is titled Mediated Trust, Ideas, Interests, Institutions and Futures, and it is particularly focused on trust in 4 domains with regards to news, digital platforms, institutions and artificial intelligence.
I'll come back in a moment to ask you about the notion of mediated trust that you address in your statement. You're also the co-director of the Centre for Artificial Intelligence Trust and Governance at the University of Sydney, established in 2023.
That's correct.
And your other experience and qualifications are set out in your statement. Professor, you have addressed questions asked of you by the Commission and set out your opinion in the expert report. What I propose to do is to go through some aspects of that with you for present purposes. The first section of your report deals with some foundational concepts, and you address in that context what you describe as the platformisation of communication. And I just wanted to ask you about that. You have said in the report that the term platform has increasingly come to be understood in terms of a particular digital business model. Could you explain that, please?
Certainly. Thank you very much for the question. That in terms of computing science, platforms have been understood as sitting within what we can refer to as an internet stack. So you would have the underlying infrastructure upon which sit platforms, which are the major companies we're talking about in this hearing today, and on top of that sit applications and services and content. Now, we can have a kind of 3-stage understanding of the evolution of the internet here, if I could indulge the Commission to provide a history of the internet in a couple of minutes. First stage, we're effectively talking about the open internet, the World Wide Web, and we have a networked infrastructure that is not owned or controlled by any individual or state or company and so forth, but which is upon which platforms sit, okay, or which content creators sit. an evolution that happens over the course of the 2000s and 2010s is that the internet is increasingly platformised. That is to say that when we communicate through the internet, we're increasingly communicating through platforms which are owned and controlled by particular corporate entities, be they Alphabet, Meta, X, and others that we're discussing. And this means that the platform infrastructure is both a means by which we increasingly communicate with one another and a profit-generating entity for these companies. And these companies have certainly been the fastest-growing companies globally over the last 15 years. This presents us with some particular challenges, I would say, in that we're talking on the one hand about the regulation of businesses, and in many respects the onus on regulating businesses is not in itself contentious, although we debate the degree upon which we do so. But we're also talking about regulating communication and regulating speech, and that takes us into more complex legal, philosophical and operational questions. Over the last decade, I would say, there has been a turn towards what I'd call a third stage of the internet. We're increasingly talking about a regulated internet, that increasingly nation-state governments are seeking to, in response to the expectations of their citizens, control or tame this environment in different kinds of ways. This presents some very distinct challenges for partly the reasons I've indicated around the nature of speech, but also partly because we're talking about global platform companies, and we're talking about national governments seeking to apply regulations. And as you would understand, there's not really much momentum at the moment towards moving towards transnational modes of governance there.
You've described how, in your view, the largest digital platforms are now best understood as platform ecosystems because they are interconnected clusters of content, services, applications and user communities. One particular example you draw attention to is the effect that this has on producing and publishing news content. Could you explain how that is a good demonstrator of what you've referred to as the multi-sided markets in which digital platforms operate online?
Certainly, and I use that example because the Australian Competition and Consumer Commission's digital platform inquiry, which has recently concluded, undertook a very detailed analysis of the implications of this for news organisations. That the major platforms that are involved operate across three markets, at least three markets. So they engage with consumers, they engage with advertisers, and they engage with the content creators, most notably here, the news publishers. Whereas the news publishers have a more limited range than the digital platforms in this regard. So there is what's been referred to as a frenemy relationship emerges here, where the news publishers require access to the digital platforms in order to amplify the reach of their content, but these platform companies are competitors to the news organisations for advertising revenue, and the ACCC documented that Meta and Alphabet accounted for about 70% of digital advertising revenue in 2019, and digital advertising revenue at that time accounted for 50% of all advertising revenue, and hence the market asymmetry that has been felt to exist between the news publishers and the digital platforms, which in Australia has been responded to through the passing of the News Media Bargaining Code in 2022 and the current proposals for a news media bargaining initiative. But it is to say that as aggregators of content that operate in what economists refer to as multi-sided markets, these are uniquely powerful corporate entities.
In this section of your statement, in which you deal with foundational concepts, you have also made some observations about two other things. One is social cohesion as a broad topic, and the other is the notion of mediated trust that you refer to. Can I just ask you about each of those? In respect of what you've put in your report about declining trust and social cohesion in Australia, you've referenced the Scanlon Foundation's work and its scale or measures of social cohesion in its index, and referred to the fall in the social cohesion index from 88 in 2021 to 78 in 2024. So what do you take from that, and perhaps if I can ask, why include this as one of the foundational concepts when considering regulation of online environment?
Certainly, because one of the questions around trust is the question of trust in the information upon which we make everyday decisions. So the sociologist Nicholas Lerman has said that in the absence of trust it would be impossible to get out of bed of a morning, that quite simply you have to have expectations of confidence in others to behave in certain ways that will at the very least not be damaging to you and will potentially be good for you. The trust literature tends to divide between what we might refer to as the psychological and sociological approaches. So trust can be a state of mind or a belief or an expectation of particular individuals or groups. There are challenges in aggregating that upwards. So is it meaningful to refer to trust in a whole society? We can have different levels of trust in particular institutions, be they the media, the courts, the corporate sector, and so on. So we use a proxy measure there for social trust, which is that around social cohesion. And the Scanlon Foundation Index of Social Cohesion, established in 2007, and which was founded through Monash University, uses 5 metrics through which to measure social cohesion, including belonging, worth, social inclusion and justice, participation and acceptance or rejection. And as you noted, there has been a significant decline in those indices over the last 5 years, which is also mapped by the work released earlier this year by the Australian National University National Security College on its research into Australian attitudes to national security, risk and resilience, which found a significant jump in concerns around national security. And importantly, national security was understood not simply in terms of traditional matrices of security, such as the likelihood of foreign invasion, for instance, but also concerns around AI-enabled threats, misinformation, threats to critical infrastructure, and economic threats. And there has been a very significant jump in concern about terrorism between 2024 and 2026. In terms of overall measures of trust, those such as the Edelman Trust Barometer, undertaken by the Edelman Corporation for the last 25 years, has found that Australia has a middling level of trust in its institutions, so ranked about 14th of the 28 countries surveyed, and that's been a generally where Australia has sat. Although I would say Australia has a significantly lower level of trust in its media than the global average. Now, we may want to talk about how media is being defined there, because obviously the platform environment is increasingly constituting media as we understand it. It's not simply traditional print media or broadcasting or news publishers.
You have developed a concept of what you describe as mediated trust to explain the process by which communications between individuals within society are now mediated or directed through new methods of communication, in particular online communication. Could you elaborate on the idea of mediated trust?
Certainly. The question of trust in distant others has been a long-standing issue. So the reliance that we have to have a reliance upon the behaviours of others who we can't know. Okay, so if we need to get the bus or train to work, that requires a certain level of trust in the bus driver or train driver to turn up and deliver you to your destination. And you can't really know it, nor should you need to know anything about the bus driver or train driver's attitudes. You need to have the confidence that they will acquit the task for which they're required to do so. Now, in the information space, this means that increasingly we're reliant upon institutional providers of information as the basis on which we make decisions. So communications has moved from a primarily face-to-face activity to unmediated at different points of time through different technologies, and in the digital space in which we now talk, those technologies have particular affordances that impact upon how we understand trust. And so some of the concepts we will be talking about in this inquiry, including algorithmic ranking of content, user-generated content, the uses of big data, and so forth, increasingly inform the information which we receive.
Thanks, Professor. Can I take you to the next part of your report, which addresses opportunities for platform moderation and regulatory design? And you've referred to a historical approach, as it were, where there's a three-part approach to platform regulation based on legislation, regulation, and what you've described as governance. And you've made the observation in section 2.1 of your report that it's been governance rather than government regulation that's been the dominant mode of regulation for online technologies. And could you describe that, please, that governance category as it has been applied?
Certainly. So there has been a general trend towards governance as distinct from what's referred to in the literature as command and control regulation, where multiple stakeholders, including non-government organisations, civil society groups, academics and others, are engaged in standard setting. And the idea is that it is more around steering conduct as distinct from prohibiting certain types of activity through government legislation. Now, the internet has always lent itself to governance frameworks, that from the point at which the internet becomes a popular medium, if I was to put it that way, which can be broadly dated from about 1994-95, legislation is put in place, most notably in the United States with the Communications Act, which establishes that platforms are understood not to be media in the traditional sense, and this is where the safe harbour provisions of the Communications Act, what's known as Section 230, become relevant here. So,
and you're referring there to the United States Communications Decency Act of 1996?
That's correct. Yep. And I would say that provided a template, at least in the liberal democracies, so I'd say about 2/3 of countries around the world, for how the internet would be governed, broadly speaking.
And there is no broadly applicable Australian equivalent legislation to Section 230 of the Communications Decency Act, is there?
There is not. There, Section 5 and Section 7, there were the Online Services Amendments to the Broadcasting Services Act 1992, which were passed in 1998, which set certain parameters around content online and around co-regulatory frameworks. But I think it would be fair to say that their effectiveness has been limited, and to some degree could say to some degree they've lapsed. I would say, although one important point is they do give the Australian Communications and Media Authority jurisdictional authority with regards to online content, which is similar to countries such as the UK, where Ofcom was given similar powers, but quite different to the United States, where the Federal Communications Commission by law does not have jurisdictional power with regards to online content.
Yes, and just to perhaps descend into the detail of that for a moment, the US provision that you've referred to in section 230 says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any of the information provided. That's the framework in which the US has operated since 1996.
That's correct, and it was at a time. It was in relation to a case with America Online,
yes,
and it was at a time when the provider of the service was quite distinct from the platform on which the content was created. So its equivalent would be that if you're using Telstra broadband to access the internet at home, Telstra is not legally liable for any content you post from that home. Now, as you would gather, with content increasingly provided through platforms, that somewhat changes the equation there, but it doesn't change the law itself.
No, indeed. But so in Australia, there is, do you agree, no single clear principle of that sort as applies in America, but instead there are a number of laws that apply to different parts of communications in Australia differently.
That's correct.
So, for example, in the context of defamation law, there is a defence of innocent dissemination that a social media platform might take advantage of if the defence conditions are met. Yes?
Yes.
But the Online Services Act does, which is also a regulatory source of power for other aspects of what the social media platforms provide, but there's nothing like the broad provision that applies in the United States.
There's not a broad category of exemption, but there are certainly different legal frameworks based upon the platform upon which content is delivered. So, for example, there are rules around election advertising that apply to television and radio, but which do not apply online.
Yeah. You've addressed in your report the challenges of moderating harmful online content, and can I ask you about this? You've set it out in section 3.1 of your report, and you've identified 7 particular challenges.
Yes.
Could you just briefly address each of those, please, Professor?
Certainly. I would just note that there is, overlaying this, there has been a philosophical debate about whether the internet should be regulated. In the Reno versus ACLU case of 1996, Justice Dalzell observed with regards to the internet that as the most participatory form of mass speech yet developed, the internet deserves the highest protection from governmental intrusion. So there is always a debate around the legitimacy of government engagement in the online space. At the same time, as we're aware from this commission, online speech can and does have real world consequences. With regards to moderating on harmful online content, as you asked, some of the issues that arise are the scale and velocity. The volume of content uploaded to the internet every second is phenomenal. It's estimated that 6 to 8 hours of new video content is uploaded to YouTube every second, to take one example. The virality. Harmful content often goes viral within minutes, meaning that by the time a post is flagged, reviewed and removed, that content has already been viewed by a very large number of users and downloaded and shared and so on. Coded language is often used to evade automated filters. Context is relevant here, and I believe the discussion with Dr Oboler talked about some of the contextual issues. the question of universal standards, and I will just note I was also in 2011-2012 chair of the Australian Law Reform Commission's review of the National Classification Scheme, and this question of what is harmful arises in that context as well. That there is content that is clearly illegal. There is also content which has the potential to cause harm. And the second category is a difficult one around content that is harmful but legal, and the question of who is the arbiter of those questions becomes important there. So the question of universal standards, and standards vary over time. So I would say, for instance, that while the National Classification Scheme has a lot of rules around swearing, I would say there are now very few controls over swearing in media of any form that I can think of. At the same time, new issues have arisen, say issues around anorexia, for example, were certainly not something that was considered when the National Classification Scheme was first developed. There is also the point about the human costs of enforcement, that frontline moderators face a very difficult task with high levels of psychological toll and high burnout rates, and also the question of the risk of over-moderation. We may want to return to that, but questions of legality, legitimacy, proportionality and due process. So whereas, say, in the classification scheme, let's say if a film is banned, the Australian Classification Board is required to document its reasons for that, and those reasons can be appealed. If a platform company takes down a particular piece of content, that may not be known to those who posted the content. They may not be aware of the criteria, and they may not have avenues to appeal that. Now, whether that is a good or a bad thing may vary, but it's certainly quite different to how national classification schemes have historically worked, which has been around setting limits to direct censorship.
And in that respect, and going back to the comment you made about the absence or the challenge of determining the standards by which content is regarded as harmful, though legal.
Yes.
You agree, I think, that digital platform companies are not well placed to be arbiters of what is truthful information.
They would certainly say that themselves. Mark Zuckerberg, in his first appearance before the US Congress, questioned whether Facebook should be, as he put it, an arbiter of truth.
Were there any other aspects to your view that they are not well placed to be arbiters of content?
I think that decisions are made all the time. And when I say decisions, they may also be non-decisions. But I think that the bases on which those decisions are made, I would not say that they're arbitrary, but I would also say that the bases on which the decisions are made are open to debate. There's not clearly grounded constitutional bases for them, or directives from government. There's a view of what is reasonable.
You've described one of the frameworks for moderating harmful online content as involving soft law, and,
yes.
And you've referred to your view that, broadly speaking, this is the approach adopted by the E-Safety Commissioner under the Online Safety Act. Could you explain that, please?
I should say, being in a room full of lawyers and being a non-lawyer myself, I feel slightly intimidated in answering a question about what any particular form of law is. But as Ari Freiberg has observed, soft law occupies a middle position between no government interference at one end and complete government involvement at the other. It typically involves the application of code, standards, protocols, boards of review, means by which they're typically forms of self-regulation, but I don't think that the term self-regulation captures all forms of soft law. So the concept has its origins in areas like international shipping, where there is not a single global entity that can govern the seas, but there are a set of treaties, protocols, understandings, etc., through which questions like, for instance, which countries' boats have the right to fish in certain waters are determined, and these are examples of what's known as soft law.
And do you include the what you've described as the safety by design principles as part of that?
Safety by design is at the moment something of an open concept. It was articulated in the statutory review of the Online Safety Act 2021 undertaken by Delia Rickard, and it's also for some time informed the practice of the Office of the E-Safety Commissioner. The Office of the E-Safety Commissioner being established in 2017 with the intention, as put by the Minister at the time, of having a more agile regulatory framework than that provided through the legislative instruments that the Australian Communication and Media Authority drew upon. So I mentioned earlier the extension of the Broadcasting Services Act to online services, the sense that that was not really fit for purpose, and that a different entity was required that could be empowered to work more collaboratively with the relevant companies. And safety by design is in part around the principle of, I guess you might say, ratcheting up standards by working with the companies around design decisions made on their platforms that can improve the user experience while also addressing online harms and possibly being good for the commercial interests of the companies themselves.
You've also referred to relatively recent developments in the UK and in the EU, and you've addressed the EU's Digital Services Act and the UK's Online Safety Act, and your report goes on to address the Rickard Review and Australia's recommendations in respect of the digital duty of care. Could I ask you just to address one particular aspect of the UK Online Safety Act as a comparative for what might be Australia's future? You've noted that the UK Online Safety Act, in its form as legislated, involves a series of multiple narrower duties rather than one general digital duty of care. Could you explain your view about the relative merits of that approach?
Yes, those who originally proposed the idea of a duty of care approach to regulation, Woods and Perrin, envisaged the idea that it would be an overarching framework that sets out a set of principles around which companies engaged in the online space should operate, but in which the capacity to set both the means by which those were achieved and what might be the principles had a degree of flexibility over time. Now, in the 7-year history of the Online Safety Act going from being initially proposed to being finally implemented, it adopted a series of narrower duties. So there was a sense that there was a degree of legislative creep, if you like, that it was felt, well, legislation has to address this and this and this. And one consequence of that has been that the risk framework requires that risk is defined in terms of the law itself, whereas the original intention behind the duty of care was that there would be a greater degree of flexibility on the part of the regulator to determine where a risk might arise.
And as a matter of principle, do you have an opinion about the preferable approach to be adopted?
I think the lesson of this space is that there's always going to be ultimately a hybrid approach to regulation, that there are pros and cons to each framework. The challenge with there are a series of challenges with a legislative framework, partly that legislation is difficult to amend once enacted. So when situations change, the process through which legislation is amended is complex and time consuming and may not happen. The soft law approach has the virtue of being more agile. Companies involved would argue that they are best placed to understand what the issues are and therefore need to be engaged in the process of addressing the issues. The concern is that the combination of soft law and self-regulation can produce something that might be very soft indeed, particularly if the entities tasked with overseeing the laws lack sufficient distance from the entities which they're regulating. So ultimately there tend to be hybrid approaches, also I should say informed by human rights considerations which need to be foregrounded in any attempt to propose legislative solutions.
In part of your report dealing with the development of telecommunications legislation, you've referred to the Digital Industry Group in 2019 being asked by the federal government to develop a voluntary disinformation code of practice with the idea that it might operate as an adopted code in similar form to a structure that applies in the European Union. And you refer to the Communications Legislation Amendment Combating Misinformation and Disinformation Bill that the federal government initially proposed but then withdrew in November 2024. You've said that the absence of federal legislation in this area is a notable gap. Could you explain what the effect of that gap is on the publication of misinformation and disinformation online?
Yes, the movement towards a voluntary disinformation code of practice was in line with the soft law approach, that it was the hope that, I guess, enlightened self-interest might prevail in this space without the heavy hand of government needing to come in. The difficulty in implementing the code was that where a breach was found against one of the initial signatories, they simply didn't feel themselves to be governed by the code. And there was no real capacity then to apply sanctions to the company involved, which was X, formerly known as Twitter. In light of that, there was a proposal that government should have reserved powers to register industry codes, enforce industry code compliance, and make standards relating to the activities of digital platforms. So misinformation and disinformation amendment was proposed. This found itself friendless in the Senate, I think might be a way to summarise it, that it was opposed both by the Liberal National Party coalition, who saw it as unduly impinging upon freedom of speech. It was also opposed by the Australian Greens, who felt it didn't do enough to address the power of tech platforms, and it was criticised by the Australian Human Rights Commissioner as being overly broad in its definition of misinformation and disinformation, setting an unacceptably low threshold for what constituted harm, and placing excessive powers over online content with the ACMA. Now, the virtue of a piece of legislation in this space, to my mind, is the capacity to define what misinformation and disinformation might be, because the challenge that continually arises around categories like online harm, misinformation, etc., is the question of what is in the eye of the beholder. So to my mind, the capacity of the existence of a legislatively defined instrument that can state what can or can't constitute misinformation or disinformation would be an advance in terms of regulating online harm, but given the political realities, I think it's unlikely that a misinformation bill will return to the Parliament at any time in the near future. So we would be looking at other options in that regard, in which a digital duty of care may well be relevant too.
As a preferable mechanism by which to approach the problem.
As a different, whether it's preferable, we'll see, but as a different mechanism to approach the problem.
In some respects, Professor, a code respecting disinformation might impose a greater burden on the freedom of political communication than a code dealing with hate speech, depending on the definition of the latter. Would you agree with that?
It could, yes.
Yeah.
Yes.
You've provided an analysis of a particular example of the spread of misinformation or disinformation online in the context of the Russia invasion of Ukraine. I'm not going to ask you to go through all the detail of the table that you've provided, but could you identify what you draw as the lesson from that international example?
Oh, okay. What I would draw as the lesson is that self-regulation is ultimately limited. That it may lack transparency. There's the question of independence, and there's the question of enforcement criteria and the voluntary nature of involvement. So I think there's the need for a step beyond self-regulation.
You're referring there to self-regulation by social media platforms of their
yes,
content.
Self-regulation by companies themselves.
Yeah.
Self-regulation through principles-based regulation. There's the interesting experiment, I guess, of the Meta Oversight Board, formerly the Facebook Oversight Board, which was established in 2021, and which there are Australian representatives on the board, which has undertaken a form of what I call third-party quasi-self-regulation, in that it has a series of esteemed panellists from throughout the world on it, who adjudicate on content moderation decisions with the idea that this creates a body of case law that can subsequently be appealed to, and which aims to address the problem of a platform not wanting to itself be the arbiter of truth, but which can draw upon expertise, and it is funded in trust in a manner that separates the funding of the board from the operations of Meta itself. In practice, it moves quite slowly. I think it would have to be fair to say about the oversight board. There's also the question of the different environment in which the company now perceives itself to be operating in 2026 as distinct from 2019, 2020, when the board was first established. But it's a very interesting innovation in a kind of self-regulation that can potentially have some kind of legal authority and some kind of teeth. But certainly nation-state regulation can have teeth. The question is ensuring that it's compliant with human rights law and obligations. Now, we'll just mention there that some talk about, I mentioned the European Union earlier. There was a speech that French President Francois Mitterrand gave to the Internet Governance Forum in 2018, where he identified the possibility for the European Union being something of a third way, as he put it, between Silicon Valley self-regulation and high state regulation of the kind we find in the People's Republic of China. And the EU is often referred to here, where we're looking for mechanisms that have some kind of a balance between, if you like, completely free market approaches and highly state-controlled approaches.
And your indirect reference a little earlier to the changed regulatory atmosphere in the United States in 2026, could you elaborate on that?
Of the second Trump presidency.
Yes.
And the very strong alliance between many of the leading tech companies and that presidency.
And to your observation, is that has that involved a renewed emphasis on the absolute nature of the entitlement of social media platforms to publish content?
It's certainly involved the dismantling of a range of mechanisms that had been applied within the companies, such as the operation of trust and safety councils.
Yeah. In the next section of your report on hostile misinformation online, you have referred to the hostile misinformation effect. Could you explain what that is and how it's relevant to an understanding of what occurs online, which is itself necessary to understand how to regulate it?
Sure, most certainly. It builds upon what's a long-established concept of the hostile media effect, which is that two individuals with different political or other orientations can view the same piece of information and perceive it to be balanced or biased quite differently. So the perceptions of bias. This is the question around: can you get an objective measure of bias that differentiates itself from perceptions? And the authors involved in this European study argue that this has translated to the online space, where people will perceive the information environment as being particularly hostile to their own perspective or point of view. It's also quite likely to coexist with which party is in government. So a symposium that took place at Griffith University in Brisbane last week produced a report on trust in government, trust generally, but also trust in government, which found that in the current survey, Labor voters were twice as likely to trust government as coalition voters. Now, I dare say if you had a different government, that figure may flip the other way around. I don't think it's something that's intrinsic to the people surveyed, as distinct from their likelihood of perceiving government to be more trustworthy if a government that they elected is in power.
You've also addressed perhaps the other side of the coin, or at least another relevant aspect, is the psychological motivations behind those who provide or publish misinformation.
Yeah.
Could you address what you've said in your report about that?
Sure. Well, I picked up on Dr Oboler's comments earlier that in some instances it is motivated by a kind of in-group identity, and social media can amplify the construction of in-group identities by promotion of posts that are perceived to be hostile to the perceived outgroup. Social media platforms can particularly promote that form of affective polarisation. It can also be quite simply around money. So in the studies of fake news, there were the famous Macedonian teenagers who suddenly were driving Mercedes around the village on the basis they'd identified a way to game YouTube for Trump supporters with content that would bring advertising to them. That hence they had a Mercedes. Whether they were particularly invested one way or another in the content they were posting was a quite different question. It was primarily a commercial interest.
When you're addressing psychological motivations, you also refer to the fact that there's yet another category of poster who may simply have a willingness to be disruptive or non-conscientious rather than actually holding a view consistent with the information that's being published.
Yes, there is the question of whether people say things online that they wouldn't actually say to the same person or group were they in a face-to-face environment with them.
And that itself might have different psychological drivers.
Yeah.
You've recommended in your report that to the extent that nation-state governments have a role in setting content moderation rules and guidelines, you consider there are 5 principles that should govern their activity or their actions. What could you address each of those in briefly, please?
Certainly. So the 5 principles are legality, legitimacy, proportionality, due process, and harmonisation to the greatest degree possible. So the principle of legality is that terms of service should be clear and comprehensive, and that any applications of restrictions on online speech should be based on legally clear criteria. Legitimacy, that, and this is where the question of whether platforms can effectively self-regulate partly comes around the legitimacy question. Are there avenues to appeal? Is there due process in decision making and so forth? And also that remedies should be proportionate to the matters raised, and to guarantee online and offline security without unduly inhibiting upon freedom of speech, and that some form of due process exists, and that to the greatest degree possible nation states should look to harmonise their laws and regulations in this space with other certainly comparable nation states and international law.
And by that, are you referring to the European and UK examples, or is this a general principle?
Yeah, as a general principle. So whether it be the various United Nations conventions, some of the principles that have been developed by international non-government organisations, such as the Manila Principles, the Santa Clara Principles, and certainly given that the platforms involved operate across multiple jurisdictions, the extent to which we can minimise pressures towards what's referred to as the splinter net, where if you go to a different place you're dealing with a different internet to the one you dealt with back home. So for instance, not being able to access the New York Times in Beijing or whatever it might be, we aim to minimise the extent to which, given that one of the greater virtues of the internet is this capacity to operate as a global network, that we aim to harmonise laws and regulations to the greatest degree possible.
Generally, do VPNs create a difficulty in that regard? So that if Australia imposes particular regulation, would you expect that could be readily avoided by someone in Australia using a VPN?
It can. It certainly can. I mean, this one comes up most notably around pornography. It certainly can. I guess the point would be that the existence of the law provides some capacity to deem that to be in breach of the law, if I was to put it that way.
Professor, you've provided a series of recommendations in your conclusion. We've addressed, I think, most of them in the course of the questions I've asked, and they can perhaps speak for themselves. But you've referred to the co-regulatory approach, in which self-regulation alone will not achieve an appropriate outcome.
Yes, there may be an opportunity here with the pending digital duty of care response of the federal government to the Rickard review, in that it provides a capacity to reinstate, if you like, principles of social licence and align those to questions of best practice. I think there is potentially an opportunity here that the challenge with the self-regulatory models is always well what happens if some entity chooses to simply ignore them? Where does legal teeth exist? And there may be capacity through a revised Digital Duty of Care Act to put some kind of legal teeth there, while at the same time promoting principles around social licence for platforms that are keen to work with governments and others around the matters of public concern we're addressing.
And can I ask you to address specifically your sixth conclusion and recommendation, where you say it's important for governments to actively support trusted sources of information?
Yes.
Could you just elaborate?
Sure. Well, I think we don't want the existing news media infrastructure to collapse. I know when I say we, I would say I do, but I've concluded a study on the sustainability of news publishers, and a book that's recently come out called Valuing News, which addresses this, that the News Media Bargaining Code has been one instrument through which this has happened, that it is effectively it's a requirement that the major digital platforms, and it's been Meta and what was then Google in the first instance, reach agreements with news publishers around payment for redistribution of content. That's been extended to a news media bargaining initiative. There's some debate about whether all platform companies are going to comply with that. I think over time we're possibly looking at government support for commercial news. I think that in addition to funding for the ABC and SBS, I think that questions around news deserts, around the loss of jobs in journalism and the loss of news infrastructure are going to are pressing at the moment, and the question of it's not apparent that the market itself can solve the problem. So we know enough now about the basis of subscriptions to know that subscriptions will provide a basis for some media, but not all media. This will present issues around both around funding, and I have elsewhere suggested the possibility of a digital advertising levy, noting that the word tax should not appear in this because that would be contrary to the Australia-US Free Trade Agreement, but some form of digital advertising levy. And then there would be the question of how those funds would be distributed without the process being perceived to be politicised. I think that's a question in its own right. But I think that there is a market failure case for support for public interest journalism.
Some years ago, Professor, there was concern by major media companies about the fact that the public broadcasters were moving into the online space. Given, as I understand it, the tendency for younger adults to obtain their news from online, do I take it is significant that the public broadcasters are funded to provide for online content as well as the legacy platforms?
Oh, absolutely, and I think the distinction is really starting to blur. Just interestingly, on that, the most recent edition of the Australian Digital News Report has come out, which found that younger people actually have a higher level of trust in news, and also there seems to be a significant uptick in younger people using the ABC and SBS as sources of news. I recall that this generated some surprise around the room, but it was an interesting and generally perceived to be positive development.
Thanks, Professor. I don't have any further questions.
Yes. Thank you, Professor. Dead on lunchtime, you are excused.
Thank you.
Yes, I'll adjourn till 2 p.m.
Commissioner, the next witness is Dr Nicholls.
Yes. Dr Nicholls, will you take an oath or an affirmation?
An affirmation, please.
You solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth.
I do.
Dr Nicholls, what is your full name, please?
My full name is Robert John Nicholls.
You are the a senior research associate at the University of Sydney Centre for AI Trust and Governance.
I am.
You have prepared an expert report dated 25th of June and provided it to the Commission. It is a document that bears the ID EWR.599.0001.0017. Attend to the report.
Yes, the report will be received as an exhibit.
Dr Nicholls, the contents of the report reflect the opinions you hold.
They do.
And Commissioner, the report attaches a number of exhibited documents, RJN 1 through to RJN 8,
Yes.
and solicitors assisting have prepared a bundle of referred to documents from the report, and I collectively tender the attached documents and the referred to documents.
Yes, and do Council have a list? I gather from the nods, yes. Yes, very well. Those will collectively be received as an exhibit.
Dr Nicholls, can I ask you first to address your training and experience? Your bachelor's degree was a Bachelor of Science in Electronics and Communication Engineering.
It was.
You did a Master's in Politics and International Relations.
I did.
And there followed a PhD at the University of New South Wales in 2011.
That's correct.
And what was the subject of your doctorate?
It was the regulation of broadcasting 1923 to 2006.
You have a extensive experience in the area. You were a consultant and for a time a partner of Gilbert and Tobin in Sydney, advising on strategic and technology advisory services in the fields of broadcasting and telecommunications.
Yes.
You were with the ACCC for a couple of years as a general manager.
I was.
You spent some time as an adjudicator of the Office of Independent Telecommunications Adjudicator.
I do.
And then you spent over a decade as an associate professor at the University of New South Wales.
Yes.
Before crossing the city to join University of Sydney more recently.
Absolutely. Yes.
Not only crossing the city, but getting an office in the quadrangle.
Absolutely.
Dr Nicholls, you have in your report addressed a series of questions asked of you by the Commission, and the first and very general question is, how could Australian regulatory frameworks that exist for copyright or licensing or telecommunications be used or adapted to regulate the dissemination and proliferation of hate speech and harmful content?
Yes.
Which of course includes anti-Semitic and other religiously motivated extremist content online. For the purposes of your report, can I start with question 1 and your answer to it, which
Yes.
is to describe the existing Australian regulatory framework. And in the first part of your report, you address section 115 capital A of the Copyright Act,
Yes, I do.
which provides a regime for site blocking.
That's correct.
Can you just briefly describe what section 115A does and has proven to do?
So, section 115A is designed to deal with egregious overseas sites which have copyright material, and these include musical copyright material and movie material. One of the first was Pirate Bay from which one was able to download almost any movie that had ever been made. The mechanism is that the copyright holder or a representative of the copyright holder seeks an order from the federal court to have that site blocked. The legislation provides a number of ways in which that site could be referred to for blocking, and in practice the blocking is through a process called domain name server blocking. And it means that for most people in Australia, when they try to get to a site which has been the subject of a 115A order, they find either nothing or a web page that says that the content isn't available.
Can I address with you for a couple of minutes the underlying technical processes that Section 115A targets and uses for the purposes of blocking access to a site? You've provided as an attachment to your report a technology primer.
Absolutely.
And if you have a copy of that, I just want to take you to a couple of paragraphs in the primer. This is document EWR.599.0001.0139. Perhaps the first observation I want to draw to your attention is what you say in paragraph 40, which is, from a network perspective, browsers and apps use the same underlying internet infrastructure. So there you're referring to internet browsers on the one hand and apps or applications on the other.
Absolutely, yes.
So could you explain how they commonly use the same infrastructure?
So the mechanism by which content is delivered to either a browser on a screen or an app on a phone or on a computer is technically identical. That is, there is a request for the material to be provided and it is displayed. The distinction comes between the two. With a browser, there needs to be enough information to be able to display it in the way that it was intended. And there are standards for things like hypertext markup language, cascading style sheets, JavaScript, so that if I'm using, for example, Chrome and you're using Microsoft Edge, we will end up with the same look and feel to the screen. In an app, though, although the same mechanism is used, the way that the material is presented is determined by the app developer. So if I'm, for example, if I'm Meta, I allow access to Facebook using a browser and it will have a particular look over that browser. If it's delivered to a Facebook app, the look on the app is determined solely by the app provider, which is Meta.
In terms of access to the Facebook app, in terms of the way a user comes to view content, is the structure of that in technical terms the same as the way you see a web page through a browser, or is it different?
It is broadly similar, and the reason for not saying it's identical is that it doesn't need to be identical, because the information that's required by the browser to give a particular look isn't required by the app, because the app knows how to, without anthropomorphizing, the app is instructed how to display the information.
Yes. And then the process of DNS blocking is explained in your primer paragraphs 56 and 57.
Yep.
I take you to that. So you've put in the middle of paragraph 56 that the person who controls the DNS server can deliberately configure the DNS server to make it perform incorrect translations. In
Yes.
other words, to make it inaccessible to the user.
Yes.
And paragraph 57, you draw attention to the fact that it is the one or other of the Australian ISPs who provide access or configure the DNS server in question. Is that right?
Each of them may have their own DNS servers, and usually each does have their own, which is why typically an action taken under 115A has multiple carriage service providers or internet service providers as the respondents, so that each of them configures their own DNS server to provide the block.
Yes, and so for example, the 115A case that you referred to against Pirate Bay, the respondents to that application to the court were a whole series of Australian ISPs who each controlled their own DNS servers, and they were each required by the court to block access to the Pirate Bay.
Absolutely, at the cost of the applicant.
At the cost of the applicant, yeah.
And was that successful against an Australian using a VPN?
No, Commissioner. So the design of Section 115A is partly focused on ensuring that you don't accidentally or via a search engine come across these egregious breaches of copyright, but it doesn't prevent VPN access because the carriage service provider can't prevent that access.
And I'll come back to VPNs a little later in my questions. In paragraph 67, you express an opinion that a significant majority of Australian residential and mobile internet users do use the DNS servers of their ISPs.
I do, and my basis for that is that it's much easier to take the configuration that your internet service provider or carriage service provider offers you than to configure in an alternative way. And messing up the configuration of DNS server on your computer means no access to the internet.
Yes. Now, the technical measure of DNS blocking is technically available to Australian carriage service providers, Australian ISPs, to block access to the whole of a social media platform. Is that right?
It is, but it would block the whole access, not individual pages.
Yes. Let alone individual content.
Absolutely. So it's
now, you've addressed in paragraphs 46 and following of your statement reasons why 115A can't simply be applied to hate speech on social media, but that is one of the essential reasons.
It is that essentially you can block a domain but not individual pages or content within that domain.
Nevertheless, I think you contemplate later in your report that if, as we'll get to, there were a recommended structure as you propose where there is either a registration or licensing regime, the ultimate sanction under any such regime, it could be an ability simply to switch off that particular social media platform.
Absolutely. So a social media site that was not compliant with Australian law could be blocked in Australia.
And that would be to those using the DNS servers of their own ISPs.
That's
rather
right.
than users of VPNs.
That's correct.
Now, you have addressed what you've described as a parallel regime modelled on 115A designed for hate speech. Could you provide a brief summary of how you think that could work, at least in theory?
In theory, if for example there was a website that was set up with the purpose of providing hateful or obnoxious content, then addressing and blocking that website would be feasible using a regime like Section 115A. It's so not a social media platform But if there was a deliberate decision to set up a hateful page, it could be blocked using that technique. But that's the limitation of the technique.
Yes. Now, you have addressed in the next section of your report the licensing framework, what you refer to as the current licensing deficit.
Yes.
And refer to the operation of social media platforms in that context, where you have identified a class licensing deficit as a structural impediment to regulation. Could you explain what you mean by that?
So both carriage service providers and content service providers are class licensed. That is, they hold a license by virtue of falling into a specified class. There is an obligation under the Telecommunications Act for each of them to abide by the relevant service provider rule, carriage service provider rule or content service provider rule. But that does not currently, there's legislation before the House, but that doesn't currently require any form of registration. And as an example, in the telecommunications environment, if a carriage service provider is providing services to the public, they are obliged to join the Telecommunications Industry Ombudsman Scheme, so that if they upset one of their customers, the customer has a complaint mechanism. But the legislation itself, the class license itself, doesn't require registration. And what that means is that we have a series of content service providers and carriage service providers that operate within a class license but have no location. We don't know who they are, where they are, and what they're doing.
You've referred in paragraph 68 to the consequences of a platform operator having no Australian corporate presence and no assets. Could you elaborate on that, please?
Yes, so because the content, the social media platforms as carriage service providers, I think that's the...
Yes, I think that's paragraph 68 of the primer. I've just gone back to paragraph 68 of your statement.
That because there's no obligation for registration or licensing, social media platforms can operate without having presence to sue or be sued. So there is no requirement to have presence to accept service.
Now, you've noted that the Rickard review of the Online Safety Act made a recommendation that consideration should be given to introducing a licensing scheme, and you've noted that the Commonwealth did not support the recommendation.
Yes.
You have expressed the view, and we'll come to it in more detail a little later, but at this point in your report, paragraph 71 and following, you set out some of the reasons that you consider that a mandatory licensing or registration regime for social media platforms would contribute to hate speech regulation in three important ways. Could you address those three ways, please?
The first one is accountability, so that there is a requirement that the social media platform operating in Australia is accountable for its actions in Australia. So essentially this is a mechanism that would would avoid the problems that the Safety Commissioner has had in trying to serve X Corporation. It would provide a little bit more certainty, as I heard in the media on Monday, for this commission to be able to interact with certain social media platforms.
And you've used the expression jurisdictional arbitrage in this context.
So it's very easy to say, and there was evidence before the Joint Select Committee on Social Media in Australia to say, well, our Australian representatives are the people who are market specialists, but everything else that we as a social media platform do is done overseas, and potentially we don't even know where it's done. So if instead of getting rid of the jurisdictional arbitrage is by saying, no, if you operate in Australia, you register to operate in Australia, you abide by rules associated with that registration, and essentially you take responsibility for all the services that are provided in Australia, regardless of whether they're domiciled in the US, in Ireland, or in the Netherlands, depending on your internal tax purpose regime.
You go on to make the point that a licence or registration regime would allow the imposition of conditions on either the licence or the registration continuing.
Yes.
And that would provide an opportunity to incorporate substantive content moderation requirements. Is
Absolutely,
that right?
yes. And would provide a single point on which those obligations could be imposed.
Yes. A single point, as in a corporate point.
Yes.
Yeah. And then the third, excuse me, the third consideration you refer to is an enforcement pyramid. As
yes.
You refer to it. What does that mean?
So an enforcement pyramid, which comes from the work of John Braithwaite to ANU, essentially says at the bottom, most activity by regulated entities is guided by guidelines, by advice, by the regulator making statements. Up from there is a first level of regulatory enforcement. It might be something like if an entity errs, that it might pay a speeding fine, an infringement notice, and give an enforceable undertaking, an undertaking enforceable to the federal court.
Yes.
Above that, the next level of the pyramid is enforcement with penalties, typically through the relevant court, the federal court, and at the apex of the pyramid, and fairly rare, criminal activities. So, for example, cartel conduct can be criminal conduct, so that you have a pyramid where most of the activity occurs at the base, and if things go horribly wrong, you're at the apex.
You've addressed in your report two different approaches. One is what you call the registration alternative, and the other is the licensing
yes.
regime. And is it fair to say your preferred recommendation is a licensing regime, or you think they're functionally much the same?
I think they're functionally much the same, and perhaps your profession is an example. When you were called to the bar, you joined a register of barristers. You don't strictly have a barrister's license, but you are nevertheless subject to an enforcement regime. So that they are broadly similar. Licensing becomes a bit clearer because you can have individual licenses. Registration, typically all of the members of the register would have the same obligations.
And in paragraph 76, you summarise a more detailed description of the registration alternative that you provided in one of the annexures to your report, which is annexure 8. I won't bring that up, but paragraph 76, I think you summarise the main features of the registration regime, where your suggestion is that it would require every provider of a social media service or age-restricted social media platform accessible to Australian end users, regardless of the provider's place of incorporation, to have those 4 central features.
Yes.
One is registration with ACMA,
Yep.
The second is the nomination of an Australian entity with a domestic address.
Yes,
A financial sufficiency certificate.
that's correct.
And what does that
So
achieve?
So the financial sufficiency certificate means that if enforcement action is taken, that there are sufficient funds to pay penalties associated with that enforcement action.
To avoid the problem you referred to earlier of an overseas entity with a relative company in Australia with no assets.
Absolutely, yes.
And then the fourth feature is the designation of a principal entity within the corporate group. Are you referring to an individual or a board or a combination of things?
I see it as a combination of things, but ultimately it would be a body corporate which takes that responsibility.
In paragraph 78 you set out your opinion, which I think is consistent with what you said, and perhaps there's a fair degree of functional similarity between a registration regime and a licensing regime, subject of course to the detail of the structure.
Yes.
Is a licensing scheme better able to accommodate a variation between conditions imposed on a licensee that may be different from entity to entity?
Yes, so licenses other than class licenses are individual, whereas they can be common. They often have distinguishing elements to them. So for example, in telecommunications, a telecommunications carrier license is a fairly standard document for most entities, but for Telstra and Optus there are differences, and they are specific individual differences. The advantage of a registration scheme over a licensing scheme is that there can clearly be no discrimination occurring, so it's in the context of international relations, it ensures that there isn't an argument to say, well, you're targeting US domiciled businesses or China domiciled businesses.
Yes, and you've given some explanation in your report of both international agreements and international diplomatic considerations.
Yes.
That would favour a structure that obviously does not infringe, for example, a free trade agreement with the United States.
Absolutely.
In the section of the report that I'm asking you about, you have also addressed some of the existing structure,
yes.
Legal structure of regulation of telecommunications, and you have, we've addressed paragraph 81 and 82, which is the limitations you see in the network level blocking under the
Yes.
some analogy to the 115A of the Copyright Act. Could you just address briefly the Scams Prevention Framework Act, the 2025 model, and how, if at all, that might be useful in considering comparisons?
I think the Scams Prevention Framework Act is useful as a guide, in that it applies both to platforms, to social media platforms, and to carriage service providers. And together, its intention is to stop, it's to create a protection for consumers from scam behaviour that operates on both platforms and over telecommunications networks. I provide it primarily as an example of we can actually do this and we do it, as opposed to this is a way of dealing directly with hate speech.
And I think you said in another context, it's not so much that there are technical limitations or even legal or structural limitations, but in your view, it's a question of political will.
That's correct, yes. And you asked me earlier about the response from the government to, as regards review of the Online Safety Act. the decision not to progress on licensing was a political decision.
You've also addressed the telecommunications law approaches, that is, the existing approaches to various types of regulation of telecommunications. One particular aspect I'd ask you to elaborate on orally is what you've set out in 103 and 104 of your statement, which is the ACMA alphanumeric SMS sender ID filtering regime. Now that is quite a mouthful, but
it is. It's a regime that comes into effect today.
Yes.
If you, I'll step back. What's the problem it's trying to solve? If you get a text that says it's from the Royal Commission, and instead of having a number it says Royal Commission, then you will tend to regard that as having some weight. The problem that the issue was designed to resolve is that almost anybody can choose almost any alphanumeric characters, and we're using them to either scam or upset people. So what this framework or mechanism does says that if you want to use alphanumerics to deliver SMS messages, you need to be registered, and essentially carriage service providers and carriers will either, if you are registered, repeat this is a message from the Royal Commission, or if you're not, it will send a warning that this purports to be from the Royal Commission but isn't. So it's a mechanism by which essentially people are less likely to be scammed, so it has a scam aspect to it, but it also has a protection aspect, so that if you receive a text that says it's from Commonwealth Bank, it probably is.
You draw on this as another demonstration that the technical and operational architecture, as you call it, that presently exists in the telecommunications network is consistent with the kind of regime that you have recommended for regulation of
Absolutely.
Online hatred.
Yes.
There is also the Security of Critical Infrastructure Act 2018, which at first glance might sound a surprising possibility as something to regulate online hatred or politically motivated violence. Could you explain how this conceivably could be applied to online hatred at the moment?
So the Security of Critical Infrastructure Act is primarily has a primary object of stopping cybersecurity issues on critical infrastructure. However, it does give powers to ASIO in relation to national security issues, and as I set out, the ASIO Act defines security in a way that potentially could include hate speech in certain environments. So I raise it because it's there. I also raise it because the telecommunications, the obligations to assist law enforcement agencies and others under the Telecommunications Act moved into the Security of Critical Infrastructure Act and then back out again. So for completeness, I needed to discuss the Security of Critical Infrastructure Act.
Yes, and you set out very helpfully, thank you, the escalation pathways, as you've called them, under that legislation.
Yes.
Can I then take you to the section of your report about 153 and 154, where you identify, having considered those various existing statutory frameworks, you say there is a legislative gap and case for reform.
Yes, so I've looked at section 115A. There would be a similar mechanism under section 313 of the Telecommunications Act. So if there was material that was hosted online on a website that caused a security issue or a threat to the public purse, then there could be a takedown of that. However, it's a complete takedown of a domain in the same way as 115A does, so it doesn't have that sharpness that would be required to go after specific content in a hate speech context.
You summarise your review of the telecommunications framework not by suggesting it all be jettisoned, but rather saying that there are a most effective approach would combine elements of each of the frameworks.
Absolutely, yes.
And so could you just address paragraph 171 for the Commissioner to explain those three elements?
So essentially, my recommendation and my approach is to say we need licensing or registration for domestic accountability. We can use copyright style blocking for targeted intervention, but only for specific websites that are created for the purpose of hate speech determination. And then we can use telecommunications regulation as the way through which blocking can occur.
Now, before I take you to, in a little more detail, your explanation of the various challenges to regulating online hatred, including anti-Semitic content, can I address that part of your report that deals with non-legislative mechanisms and policy tools?
Yeah.
And it starts at paragraph 172, but you've provided a conclusion, an assessment from paragraph 219 and onwards. And what you've said there is that the effectiveness of non-legislative mechanisms as substitutes for legislative and regulatory frameworks is limited in three main respects. Now, the first of those, well, perhaps I could ask you to address those three.
So, that we have seen from history in Australia that when platforms voluntarily comply with commitments, a change of ownership can change that compliance. So Twitter, before it was acquired by Elon Musk, was a member of Digi, the industry association, abided by its codes, and then withdrew. So on a voluntary basis, there is a risk that a change of ownership or a change of policy could mean that a platform leaves. The second one is that, in general, non-legislative approaches are reactive. This went wrong, we'll try and fix it this way, rather than being able to be forward-looking to stop the problem in the first place. The last one is the cooperation issue. Perhaps drawing on training experience and study, my view is that self-regulation and to a lesser extent co-regulatory design have limits, and those limits are not found with a mandatory regime. So if you can do all sorts of things which will be helpful on a voluntary basis and on a non-legislative basis. But if you need the certainty of enforcement, and you do need certainty of enforcement, then this isn't a complete solution.
You've set out 7 broad categories of challenges of regulating offshore social media platform operators.
Yes.
And I'd just like to take you through those challenges and through what you've proposed as potential or perhaps in some instances clear ways to address those challenges. So the first of them is the challenge you identify in respect of jurisdictional breach, and you've drawn attention to some experiences in the Australian legal system that you say demonstrate that asserting jurisdiction over a major platform that declines to cooperate is resource-intensive, legally complex and time-consuming exercise, even when the regulatory power is not in dispute.
Absolutely.
And how can that be addressed? How can that be overcome?
If an entity has, if a business has an entity in Australia that can sue and be sued, is responsible for the conduct of services that are provided within Australia, then that first step of, well, is there appropriate jurisdiction here, is met by definition. So if a business is registered or licensed, and one of the obligations of that registration is to have an entity in Australia that can sue or be sued in respect of all of the services that are provided, then the first step will not happen, will not be a problem. So one of the examples that I gave was Valve Corporation, where it sounds almost trite. Valve Corporation said no refunds for software provided, and the ACCC said you can't say that. That's there are consumer rights here, but it took almost 3 years, including both at first instance and appeal, simply to get to the stage that Valve did have obligations in Australia. So getting that jurisdictional reach right means that the next level of enforcement, if required, can be applied quickly.
You've made a related point in your report that the absence of a registration requirement also means that it's not always clear which entity in a complex multinational corporate group is the relevant person for regulatory purposes in any event.
Absolutely, yes. And sadly, we have seen evidence that, again, the Joint Select Committee took evidence showing that large platforms said, well, we're responsible for this, but not responsible for A, B, C and D, which is elsewhere in our organisation globally.
Yes. The second of the challenges you've identified is corporate structure. Could you explain what you're referring to there?
It's the ability of a business which does have an entity in Australia to simply snip the corporate responsibility and let that entity fail. So if you don't have an entity with Pocket, then the easiest response might well be to let it go from a multinational corporation.
Yeah. And that is addressed also by the mechanism of registration or licensing.
Yes, along with the financial sufficiency certificate that then says not only is it there, but it's the one with the money.
The third you've identified is the directing minds problem.
Yes.
What is it and what's the solution?
Okay. Part of the issue is that the delivery of social media platforms is complex. So if there is, for example, the use of a particular form of algorithm for users in any part of the world, the person, the engineer who's responsible for developing that algorithm and their team may well be somewhere else in the world, and is most likely to be somewhere else in the world. So it's very hard to say, oh, well, you in Australia are responsible for this, when unless there's a regime that actually creates that responsibility, the answer is going to be, that's engineering in Santa Clara, or that's engineering. They've moved. They're in Peru this week. Not getting to that, the guiding mind is problematic. So you actually have to impose that.
I think the response that you provide is by analogy to the UK's Online Safety Act, which does contain a set of provisions for senior manager liability in certain circumstances. Is that the structure that you're proposing?
I am, but I think there are two things there. One is you need to have an entity locally that takes responsibility for directing mines elsewhere in the world.
Including technical mines.
And locally have senior managers who are motivated to comply with enforcement because they have personal responsibility, in the same way that you would expect directors to take responsibility in Australia.
The fourth of the challenges that you've drawn attention to is that of enforcement of judgments and regulatory orders.
Yes.
And could you explain that challenge and its solution?
So if there isn't an entity locally and there is a regulatory order, let's say there's an order that says you need to keep a minor one, record-keeping rules in Australia, unless there is a registered entity, there is a real risk that the answer will be, well, we don't do that, therefore we can't do that, as opposed to, we will do that because you've told us to do it and it's our role as a registered entity.
The fifth challenge is technical and content evasion.
Yes, that there is a risk that we need to address that is where content is said not to be in Australia, even though it might be accessed in Australia, and associated with that there are technically evasive things that you can do to make content appear not to be in Australia.
I might ask you about the special case of the VPN network.
Yes.
In terms of technical measures that might address that problem, what, if anything, can, for example, Australian ISPs or some other technical measure achieve to address that problem?
It's very limited. Dealing with VPNs there are limitations. So a VPN, a virtual private network, makes you appear that you are on a different network than the one you're actually on. So for example, if I use a VPN and set the output to be the United Kingdom, I will appear to a content provider in the United Kingdom to be there, even though I'm in Australia. There are some technical things you can, because the speed of light in an optical fibre is 2/3 the speed of light in a vacuum, and there will be amplifiers and other bits of electronics, so you will be able to tell that the source of the request is outside of the United Kingdom if I'm using a VPN. But you would then need an obligation on the person in the UK to say, oh well, if it's in Australia, we don't want to provide access. So VPNs are difficult. They're a challenge. There has been work done. PayPal has a patent which is exhibited to the one of the exhibits in the materials here,
Yes.
which is essentially looking at, can we detect if there's a VPN in order to stop fraud in payments? That's used. In Australia, Binge looks at VPN sourced from overseas to see if it comes from known VPN sites and simply blocks access to those VPN sites. So there are some things that can be done, but it's not a trivial problem to solve for VPNs, because many people use VPNs for very good reason, because it gives them more security on the internet.
You've also referred to the circumstance where at least one example you give is Telegram, which involves, and this is in the question of encryption.
Yes.
Where there is a non-encrypted component to a
Yes.
service that's provided.
That's right. So if you were to set up a Telegram group, the Telegram group is not encrypted, and messages to the whole of the group may or may not be encrypted. But if I was to send you a message by Telegram, that would be encrypted end to end.
Yes. So that's another technical challenge to regulation.
It is, and it's particularly a challenge. It's a challenge which is currently facing criminal law enforcement, where end-to-end encrypted services may be used for criminal enterprise. But if I'm a foolish criminal and setting up a group to start with, that group is not encrypted, and if I was to use if I was to do something silly like use an app where the app could be addressed, then potentially with a warrant, a law enforcement agency could see things in the clear before they go onto the encrypted channel.
Yes, as has occurred in a famous series of criminal cases.
Yes.
The next challenge that you have addressed have referred to as addressing trade law and diplomatic constraints.
Yes.
I touched on this in a question to you earlier, but you've referred to the Australia-US Free Trade Agreement.
Yes.
And how do you see that challenge and potential ways to address it?
So the primary challenge is an obligation on Australia not to require domestic presence of US entities in international trade. There are a couple of ways that can be dealt with. One is Australia, as the US has in Australian Annex 2, reserved some powers, including regulatory powers, so there is a potential for dealing with it that way. The other part of it is that in general, other countries have entered into bilateral free trade agreements with the US with similar terms, and also have legislation which has similar effect, and specifically the UK with the UK Online Safety Act and its equivalent of the Digital Services Act, and the EU with the Digital Services Act, and perhaps more tellingly the General Data Protection Regulation.
Then can I come to your recommended solution, rolling these challenges and their responses together? And paragraph 384 of your statement, you have encapsulated, I think, your overall conclusion, where you've expressed the opinion that a tiered mandatory registration and licensing framework,
Yes.
with a statutory duty of care and algorithmic accountability obligations,
Yes.
is the regulatory framework best adapted to address dissemination and proliferation of hate speech and harmful content.
And yes, but specifically a digital duty of care which is consistent with the Joint Select Committee and broader than that proposed by Ms Rickard, and that is not to be critical of Delia, it's merely that her terms of reference were to review the Online Safety Act, whereas a digital duty of care can be broader, and the Joint Select Committee took that view.
Yes, no, I was going to ask you to address each of these components.
Sorry.
No, not at all. You've answered part of the explanation of the statutory duty of care that you refer to, but could I ask you to elaborate on the content of the duty, which you have set out in your statement in paragraph 338 and 339, yes. But you've explained why you have preferred, you have explained in your report why you've preferred the approach of the Select Committee, but what is the content of the duty that you're proposing?
So essentially it would set up a duty of care which provides then a potential liability for breach of that duty of care.
But a duty to do what?
To ensure that the services minimise risk to Australians, to ensure that there's a risk assessment done, so essentially managing risk, mitigating risks that are identified, maintaining content moderation systems, including content moderation systems that have a human response to a contested output, a user complaint mechanism that has to be transparent, timely, and provides for human review, and cooperation with the relevant regulator. That's, in my view, the duty of care. It's not an extensive set of duties, in my opinion. It's merely good corporate citizenship put into a series of rules.
And the incorporation of those various obligations into a statutory duty of care,
yep.
The particular components bear a marked similarity to what might be licence conditions or registration conditions.
Absolutely.
So what is the benefit of incorporating it into a statutory duty of care?
You can, it's essentially across the referral. You could have a registration which merely has these set out as obligations for the registration, but perhaps easier to say your obligations as a registered entity are to, 1, abide by the digital duty of care set out in this legislation, 2, and then from there.
And who could sue on the statutory duty of care in this schema?
In my view, individuals could sue, but in practice, the way that I'd see it running is that the ACCC would take action. So a breach of a digital duty of care is at best misleading and deceptive conduct, at worst misrepresentation. So that there would be an action for breach because entities by their existence would be obliged to abide with the digital duty of care.
And it would be the ACCC rather than the E-Safety Commissioner because the duty is broader than the remit of the E-Safety Commissioner?
Absolutely. I recommend that the E-Safety Commissioner has increased powers specifically. The ACMA is the registrar and the ACCC takes enforcement.
Now the second component of your preferred or recommended regime is algorithmic accountability obligations, and you've described the centrality of algorithmic amplification as a feature of social media communications. Can you just explain your understanding of that technical process of amplification?
So the issue with algorithmic amplification is that certain materials are made available to people who are likely to find those materials interesting, and they will share them. So the amplification is sharing of materials, and so, or sharing of content. So the issue is that algorithmic amplification starts to say, oh well, if I'm sharing materials and the Commissioner is sharing materials, then we would expect that one of the solicitors assisting is also sharing those materials, so we'll make sure that she sees that material in order to share it. It becomes a particular issue with either hate speech or when there's been a major incident where material which isn't necessarily true gets shared. The amplification makes it worse. So, in my view, we need to address algorithmic amplification, and essentially to address it we need to turn it off where it occurs, where that occurrence is harmful. This is, I think, one of the things that the UK Online Safety Act misses, because it's still a major issue.
And you've described that platforms can take steps for
Yes.
de-amplification.
Yes.
And you've referred to a proposed de-amplification obligation.
Yes.
What is the technical process by which a social media platform would do that?
So social media platforms, the rationale for amplification is selling advertising. So as advertising sales associated with particular content go up, or advertising demand goes up, then actually the platforms themselves use that to sell more advertising. So the fact that they're using algorithmic amplification means that they also have the ability then to control it, and the basic control is stopping further sharing other than the direct sharing that's done by the individual. So you can moderate that amplification quite quickly. And what I suggest is that we actually end up with 3 levels of material, and that material that's borderline should stop being amplified. So prohibited material which you just don't want, restricted material, and then borderline material, and to impose an obligation not to amplify borderline material.
You've also expressed the opinion that the international models that you know of and have surveyed support the kind of regulatory approach that you've put forward as something you've referred to as a converging consensus in democratic jurisdictions.
Yes.
What are the features of that consensus as you see it, and what jurisdictions are you referring to?
So the jurisdictions I'm referring to are the UK, the EU, specifically Germany within the EU as a first mover in this environment. I also mention the US, but perhaps not encouragingly. The digital duty of care is essentially a relatively common approach across multiple jurisdictions. The requirement to be able to have a senior manager accountable for the actions of a business is commonly used across multiple jurisdictions. So essentially, at its heart, I'm not proposing anything terribly new. I'm merely trying to synthesize a variety of different approaches that have been used elsewhere in an Australian context.
Thanks, Dr Nicholls. I don't have any further questions.
Yes. Yes, Mr. Bender.
Dr Nicholls, I appear for 7 of the mainstream Jewish community bodies. A short number of questions for you. You mentioned in your evidence the litigation involving Valve, which arose in the context of what you described as jurisdictional arbitrage.
Yes.
Would you agree with this proposition? A well-resourced litigant like Valve has the ability to spend resources in the context of regulation of online material in a way that can frustrate the ability of a regulator to enforce it?
Yes, because litigation takes time, litigation takes takes funds to be able to do, and so yes, which is part of the reason for proposing an approach which is not litigation based, that is enforcement by a regulator based as opposed to litigation.
Yes. And of course, Valve is smaller than the larger platforms, isn't it?
It is. Valve is smaller, but it is a major provider of software for online gaming.
By way of comparison, Valve is a private company. It's 50% owned by one of its co-founders. On the other hand, the largest platforms are part of corporate groups that are amongst the largest groups in the world.
Absolutely, yes.
So the latter category of the largest platforms, of course, have the financial resources to spend almost unlimited funds on defending litigation, which is one of the reasons I think that you say the regulation approach may be preferable.
Absolutely, yes.
Another difficulty caused by the financial resources available to the platforms is the relatively small deterrent effect of pecuniary penalties. Do you agree with that?
I do.
And that's obviously because even a maximum penalty under many of these statutes may have almost no practical consequence in a financial sense for the respondent.
You're right, yes.
Does that mean that law reform might best be designed with one eye towards non-pecuniary penalties?
There are two different approaches to that question. The pecuniary penalties, even when they appear to be large in an Australian context, so for example, those from today under the Competition and Consumer Act, so the lower of $100 million, 3 times the revenue if a court can decide it and courts can't, or 30% of Australian revenue. Those are big numbers, but they are still potentially not big enough in a global context because they are Australian focused. The issue with non-pecuniary solutions is how do you design in advance what you might want to have. So it might be that a judicial body is given the power to make such other orders as the court finds necessary, but it is actually quite problematic unless there's some guidance either from the legislation itself or from the explanatory materials as to what the judge should think about in a non-pecuniary penalty order. So I agree it's a good idea, but I haven't really turned my mind to these are the types of things we might think of in a non-pecuniary penalty.
Thank you. Now, back on the topic of the cost of litigation against very large platforms, are you familiar with the litigation that was brought by the E-Safety Commissioner against X Corporation and resolved, I think, last month in relation to a notice in respect of, excuse me, transparency notice about child sexual exploitation and abuse material on that platform?
Yes, I've read it. So.
Yes, can you give a short summary of what procedurally happened in the years during that litigation?
So the E-Safety Commissioner sought material on information that she had the right to seek from the respondent. The respondent resisted providing that information, and at its heart, the litigation was by the Safety Commissioner to get specific performance of that obligation, and also for there to be a penalty paid for a failure to meet that obligation.
And that litigation made its way through judicial review up to the full federal court and took about 3 years to resolve from the issue of the initial notice. Is that right?
I don't recall how many years, but it was not a short period of time.
Would you agree that's another example of a well-resourced respondent being able to deploy its resources effectively to delay regulation against it in Australia?
Absolutely, which is why my proposed approach actually says, no, you've got an entity in Australia that's responsible. They have to have sufficient funds to pay a pecuniary penalty, and that's certified by an auditor. So to try and deal with precisely this issue, but litigation takes time.
Even when you're dealing with litigation or expensive regulatory action by a entity that has the resources of the Commonwealth at its disposal, it might be the case that the resources of the platforms are much larger even than the Commonwealth entity, might it?
Yes, but that doesn't mean that litigation will last forever. It just means that there are likely to be many more challenges than there would be in two more balanced entities in litigation with each other.
But might those features, that is the resource disparity, if I can call it that, and the likelihood of additional challenges, be an argument in favour of turning attention to special procedural or cost mechanisms in any law reform that might be enacted to permit effective regulation against the foreign platforms?
I haven't turned my mind to that. It would be something that I would be interested in exploring.
Thank you. I only have questions.
Just for my benefit, can you put to the witness the, just in broad terms, what you have in mind when you referred to special procedural or cross mechanisms? Is there something that those you represent have in mind? Did it help if I understood what that was?
It's a work in progress, to be candid, Commissioner, so I don't know too much detail, but what I can say, for example, is it would be conceivable to establish a no-cost jurisdiction, for example, in the course of regulation as a very general tool.
And indeed there are examples of that for individual consumers. I mentioned the telecommunications industry ombudsman. The cost of the ombudsman is always borne by the entity against which the complaint is made. These are low stakes issues, but yes, that's
And you were in other examples in the Fair Work Act.
yes.
You mentioned that one, at least theoretical possibility might be private individuals taking steps to enforce the digital duty of care. Might that also be a procedure in which special procedures or cost mechanisms could be in place to remove the obstacle to them doing that?
It might also be, and probably a little bit more likely, that it's a representative action rather. So notionally it is an individual, but it's likely to be a representative action, and if it is a representative action, then expecting there to be a litigation funder might mean that perhaps it's not necessary to go through a zero cost process, but I accept that you could do it either way.
But these are the sorts of procedures that one might consider in determining whether, as a matter of law reform, it may be appropriate to facilitate regulation of very well-resourced foreign platforms.
Yes, my issue is I don't have a model to say, well, this is how it was done in relation to financial services.
Thank you. The only other topic I was going to ask you about is in respect of some aspects of your conclusions in respect of the digital duty of care. Do you have your report at hand?
Yes.
And can you please go to paragraph 338, Dr Nicholls?
Yes.
In subparagraph A, you describe what the statutory duty of care should require the platform to do, and in subparagraph A, you indicate take all reasonable steps to ensure that its services are designed and operated in a manner that minimises the risk that Australian users are exposed to hate speech, etc.
Yes.
Then in paragraph 340, you indicate some content definitions,
Yes.
including prohibited, restricted and borderline.
Yes.
sure it's my fault, but it wasn't entirely clear to me whether you had in mind that the obligations in respect of, let's say, prohibited content, which is this is content that must be removed, is independent and additional to compliance with the duty of care.
It would be an implementation of the duty of care. So I see both running concurrently. So the obligations, you have the obligations under the digital duty of care. In addition, one of the obligations you have as a registered entity is to be able to de-amplify certain forms of content, clearly not permit prohibited content. What I was trying to get to is the idea of the borderline content, where the borderline content, if amplified, could create hate speech. On its own, it may, and individually, it may not be hate speech.
Can I just raise one issue so you can express a view about it? In relation to restricted content in subparagraph B, is your conclusion that content that meets this definition should be permitted to remain on the platform subject to the limitations you've identified there, provided that the platform otherwise complies with the duty of care?
The important part of that, as I saw it, is that it can't be amplified to those who haven't actively sought it out. So it's a balance between, are you allowed to say obnoxious things to your friends, or does it become prohibited content?
The language that you've used in the test for restricted content is content that doesn't meet the threshold for removal, but that a reasonable person would consider to be seriously offensive, dehumanising, or likely to promote hatred or discrimination on the basis of a protected attribute. Might that encompass what one would generally think of as hate speech?
I was trying to get to something which is horrible but not hate speech as being restricted. So I'm open to being to having alternative wording there. But my idea, the intention was, here's the stuff that's clearly prohibited. Here's the stuff that should not be algorithmically amplified, but which, if people share between themselves, is not of itself hate speech. And if my drafting is poor, and then the next stage, which is material which is on its own would not be problematic, but amplified up becomes problematic.
And would you agree that care would need to be exercised in that process not to permit to remain online, for example, content that contravened the Racial Discrimination Act, Section 18C, or the Anti-Discrimination Act, Section 20C, as presently drafted?
Absolutely, and anything that would be problematic under the crimes, criminally problematic as well.
But in speaking of a balance, as you did a couple of moments ago, Dr Nicholls, did you have in mind at all the constraints on legislative power in relation to the implied freedom of political communication?
Yes, as I mentioned, I'd raised both Lange and McCoy because yes, there is an issue there.
Yeah.
Thank you, Dr Nicholls. Thank you, Commissioner.
Yes. Anything arising, Mr Lancaster?
Just one matter, Dr Nicholls, you referred to $100 million penalties.
Yes.
Just to be clear, you're referring to the doubling of some penalties today under Commonwealth legislation in respect of what's variously called the social media ban or the deferral of access to social media?
No, I wasn't. I was referring to the Competition and Consumer Act.
The Competition and Consumer Act in respect of?
All of those things that have the high penalty.
All right, yes, okay, thank you. Yes, thank you. That's all, Commissioner.
Thank you very much, Dr Nicholls. You are excused.
Commissioner, Mr Bashara will call the next witness.
Commissioner, the next witness is Hannah Rose, who will be appearing by audiovisual link.
I see. Yes, very well.
Will you be making an oath or an affirmation?
Ms. Rose, are you able to hear us?
Hi, yes.
Ah, yes.
Will you be making an oath or an affirmation?
An oath.
Do you swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Ms. Rose, you've given a report to the Commission dated the 27th of June 2026, is that right?
Yes, that's correct.
And Commissioner, I tender that report. It bears the document ID EWR.5.999.0001.0134. And I also tender the bundle of material at exhibit range 3242 to 3329 accompanying that report.
Yes, thank you. That both the expert report and the supporting documents that you identified will be received as an exhibit.
Thank you. Ms. Rose, you're a senior researcher and policy manager for extremism at the Institute for Strategic Dialogue.
Yes, that's correct.
And you've worked as a research fellow at the International Centre for the Study of Radicalisation.
Yes.
And you're currently completing a PhD at King's College London, is that correct?
Yes, that's correct.
And what is your PhD on?
My PhD's in the Department of War Studies. I look at the role of anti-Semitism in online far-right spaces.
Thank you. And you also hold an MA with distinction from King's College London in Terrorism, Security and Society, is that right?
Yes, that's correct.
And can you just give some background on the Institute for Strategic Dialogue and what it is they do?
ISD is a think and do tank. We were established about 20 years ago, dedicated to reversing threats to democracy globally. That covers a range of threats from hostile state information operations, conspiracy theories, hate speech, and terrorism. And we work across that spectrum of harms, particularly looking at the online space. We have offices in the UK, where I'm based, in Germany, in the US, Canada, and in Georgia as well.
And has the work of the ISD been leveraged by governments around the world?
Yes, we often work with governments globally, particularly the European Commission, EU member states. We've worked with Australia, New Zealand, Canada, and the US previously as well.
And what has been your own involvement with the ISD's work to date?
I lead ISD's work on anti-Semitism in particular, although I deliver research and policy across a range of hate and extremist movements. Over the last 3 years in particular, we've delivered a large amount of work on anti-Semitism on a project basis. For example, we have established and coordinate the Coalition to Counter Online Anti-Semitism, which is a network of 100 civil society organisations and experts in 10 European countries, dedicated to the specific issue of anti-Semitism in the digital space and policy and education responses.
Thank you, Ms. Rose. Now, the Commission's specific brief to you was contained in a letter of instruction dated the 9th of June 2026. I won't go through every item in that letter, but could you just describe at a high level what you were engaged by the Commission to examine?
I was engaged in particular at 2 broad buckets. The first is the online threat landscape, the nature of online anti-Semitism, how it's evolved on different platforms, the different movements that promote it. And the second broad bucket is policy responses, regulatory responses, globally in particular, looking at the European Commission's Digital Services Act in the EU and what we can learn from it and what the transparency reports there might indicate about how platforms engage and seek to deliver their moderation policies.
Thank you, Ms. Rose. Before we get to some of the opinions in your report, I might just begin with the glossary. Do you have the report in front of you?
Yes.
And so I note on page 2, you've set out a glossary of terms that are utilised in the report. And you've noted that the report has adopted the IRA definition of anti-Semitism. Is it standard practice for ISD to adopt that definition in its policy work?
We use the IHRA definition as a useful framework for understanding online anti-Semitism. When we analyse anti-Semitism on a large basis, using big data approaches on social media, we find it to be the most useful, instructive working definition for understanding content which, in context, may be anti-Semitic. And we refer to those 11 examples there. We've looked at a range of definitions. They are all sometimes useful and sometimes less useful. Ultimately, when you are, and our analysts are coding hundreds of lines or thousands of lines of anti-Semitic posts, no one definition speaks to the entire environment. So we use that our definition as a useful working tool in combination with our own definition of hate.
And for purposes of this report, you deemed it appropriate to use that definition in a flexible way with regard to context. Is that fair?
Yes, exactly.
So I might begin then with the first broad topic that your report examines, namely the scale and the nature of anti-Semitic hate online. You note in the report that anti-Semitism is amplified by a range of diverse ideological movements, and you identify 3 in particular, namely far-right individuals, groups and networks forming one category, far-left anti-Semitic groups, and Islamist extremist actors. Can you just give an overview of those various sources of anti-Semitic conduct and actors?
Yes, absolutely. So we have considered those 3 ideological communities as places that anti-Semitism can be found. Building on that, we also look at across the mainstream and also the role of hostile states in promoting and boosting anti-Semitic content. Speaking specifically to the far right, anti-Semitism is a very integral part of far right ideology in many cases. We see a large network of online groups, individuals and diffuse networks who regularly promote white supremacist or far right versions of anti-Semitic ideology. Often that leads to and promotes specifically violence against Jewish communities. On the far left, we've considered here that in our report that far left anti-Semitism can often take a more covert manner where it's less overtly anti-Semitic, but individuals contribute to a wider environment which erodes Jewish participation in public life, and often where strays into the conflict and the debate around criticism of Israel in the context of the war, which is of course by no means inherently anti-Semitic, but can be expressed in anti-Semitic ways. And that is one of the more common forms of anti-Semitism that we see on the far left. And then of course, anti-Semitism is equally integral to Islamist online environments, where commonly Jewish people are demonized, viewed as inferior, based on a supremacist worldview, and targeted on that basis.
And in your report, you refer to a phenomenon of cross-ideological hybridization, whereby these groups, which in some respects are ideologically opposed to one another, find common cause in expressions of anti-Semitism. Can you elaborate on that phenomenon?
Yes, I think the kind of neat buckets, which I've just discussed, the ideological communities, is a useful analytical approach, but in practice, it's quite a lot messier than that in the online environment. Previously, we would consider, before the social media age, formal groups, top-down networks, in which extremist communities would operate. Nowadays, it's a lot more diffuse. Individuals can access lots of different forms of anti-Semitism, lots of different ideological communities quite readily. What that leads to is this form of ideological mixing, which we refer to as hybridization, where an individual can almost pick and mix different forms of anti-Semitism from different networks. That has included previously, and we saw this particularly immediately after the October 7th attack, different ideological actors who don't necessarily have that much in common, such as far-right and Islamist networks, uniting around a shared anti-Semitic core. They would say, we know we don't have much in common, but we're going to put those differences aside for the moment because the core enemy is the Jewish community.
And what role does the online environment specifically play in facilitating that cross-ideological hybridization?
The key point to make is access. Whereas an individual previously wouldn't necessarily have ready access to extreme forms of hate unless you would know of a specific group in a top-down way. Nowadays, very harmful content is highly accessible to any individual who picks up a phone. That can be through mainstream social media platforms where this content is available, or also through fringe communities where there are fewer safeguards and it's very easy to access very, very harmful content.
And what is the causal role, if any, of encrypted messaging platforms in fueling that?
The online anti-Semitism environment, we refer to it as a tech stack. So that's a layering of multiple different forms of mainstream platforms, fringe platforms, end-to-end encrypted messaging services, gaming servers, which extremists use for different purposes, in the same way that each of us might use Facebook for a different way we'd use X, or to a different way we'd use LinkedIn. It's the same with extremists. And so they might use a more mainstream platform for serving a more palatable form of their ideology, then funneling the user into increasingly harmful, less moderated spaces, more high harm spaces. And in some cases, these are end-to-end encrypted messaging networks, where the platform itself has a very little idea of what is going on that platform. These are closed spaces which we've seen to be particularly harmful, particularly for children who are able to be funneled into these spaces, and there are very, very few safeguards in those online spaces.
And you referred to more palatable forms of anti-Semitic content online. I take it by that you're referring to the use of memes, coded language, and other ways of expressing anti-Semitic sentiment that might evade strict content moderation policies?
Exactly. So we see that extremists and anti-Semitic actors use different codes. For example, they'll change a letter in a word to a number to avoid content moderation. They'll use emojis. They'll use memes. So a lot of inferred humour there, inferred anti-Semitism, which is only necessarily identifiable to an individual who knows the context of that meme already and is able to interpret it in that way. And that is one way in which not only is anti-Semitism normalised and violence is normalised, but they're able to evade moderation practices. And anti-Semitism is not always illegal. It's not always in violation of platform terms of service. Extremist actors are quite good at knowing what it does and doesn't cross the line. And so they're able to just stay under that line of detection on a mainstream platform, but then on another platform, or for example on a podcast, might express a more overt or clearly harmful version of that sentiment.
I see. And in your report at paragraph 13, you expressed the view that platforms have struggled to effectively respond to even the most overtly violent and anti-Semitic content. And you cite the specific example of analysis by the ISD in the period after the 7th of October 2023, which involved examining about 130 posts on X glorifying terrorist violence, and then following up days later after the content had been reported and finding that the vast majority of it was still online. Now, can you give your opinion as to why it is that even clearly violative content of that kind remains online, notwithstanding that it's been reported to the platforms as in violation of their terms of service?
I can't necessarily tell you why. I think you would have to ask the platform. What we've seen over a sustained period, and this is just one example of the type of experiences of the failures of moderation, which not only ISD has seen, but a number of civil society organisations and communities have seen, is that either the terms of service, so the community guidelines, aren't relevant to the online landscape, which is continually evolving, or they're not effectively enforced. That could be due to the automated moderation system, again, not being continually updated on the types of anti-Semitic or violative content available, or it could be because the human moderators aren't trained to identify that form of illegal content or hate speech or terrorist content. In this case, I couldn't guess as to why the platform wasn't able to identify branded Hamas content and remove it in a timely manner.
Yes. And we'll get to the various techniques of content moderation in a moment. But staying with the work that ISD did around the 7th of October, can you give us a sense of how anti-Semitic content online has changed in terms of its volume, its content, and its nature since the 7th of October?
So immediately after the 7th of October attack, we set out to analyse the volume of anti-Semitic content on YouTube videos about the conflict. And we found a 51-fold increase in the volume of anti-Semitic content on those videos. Of course, suffice to say that the number of videos went up, so it's reasonable that the number of comments went up, although there would, of course, have been videos about the conflict before 7th of October, but even proportionately to the number of videos, we found an increase. I think we found a 2.5% increase proportionately to the number of videos. So the kind of anti-Semitism, counter-anti-Semitism sector largely will think about October 7th as letting anti-Semitism out of the box. Since October 7th, we've seen a rise across mainstream and extremist platforms, a rise in attacks against Jewish communities globally. We've seen communities isolated from civil society, and it's had that chilling effect on communities and therefore eroded their ability to participate in civic life and in democracy writ large. And so we have this whole, what we call a long tail of harms. We're keen to not just think about this issue as the promotion and mobilization of violence from online spaces, but consider the wider impacts of extremism, not just violent extremism, but wider extremism on the Jewish community. And we've been able to evidence that through our work with communities around the wide range of harms there.
And addressing that long tail of harms that you mentioned, you talk in your report about the importance of upstream prevention strategies in particular. Can you elaborate on that?
Exactly. So we refer to the public health model for violence prevention or for countering hate. And here you can, if you think about anti-Semitism, for example, as a virus, you would have 3 tiers of how you respond to a public health incident, such as a pandemic. So in the primary tier, you would look to build resilience among society to that disease. In the secondary tier, you would look to treat those who have become slightly ill with, for example, a drug or a rehabilitative measure. And then in the tertiary tier, you would look to rehabilitate those who have been ill back into a healthy community. We can think about it in the same way for violence prevention or for anti-Semitism prevention. And this is a increasingly common approach in the sector and among governments as well, which makes sure we look at this range of engagement with anti-Semitism, not just violence prevention itself. And so in a primary tier, you would want to consider things like digital literacy training, inoculation or pre-bunking of anti-Semitic beliefs. That's not just for children, it's also for adults, and considering the ways in which adults can engage with social media in a more pro-social way. In the secondary tier, we look primarily at counter-narrative or counter-speech campaigns and how we can deliver those more effectively. And then in the tertiary tier, it's often off-ramping one-on-one support to those who've been very involved in highly harmful movements. And so this approach, this public health approach, looks to address all those things at once. What we often see on a policy level is that these policy areas can be quite siloed. So you'll have your counter-terrorism, law enforcement, intelligence services not necessarily understanding their role or working with people working on cohesion, interfaith, also siloed from digital and the regulatory approach. And so what we are always trying to encourage is increasing cross-government collaboration to understand all the sectors that are involved in the prevention of anti-Semitism and how they can increasingly cooperate in this more diffuse online environment where threats are coming from more places than they previously did.
Yes, and this links with another concept in your report about the post-organisational nature of the anti-Semitism landscape. Could you elaborate on that briefly?
Exactly. So 10 or 20 years ago, when you would think about extremist movements, you would think about groups with a leader, regular offline meetings. Often that would be quite ideologically top down. So if you think about Islamist groups, for example, they might still operate in this way, where there is an ideology which is filtered through the organisation. Nowadays, the online environment doesn't function as a set of groups. It functions as a diffuse network of individuals, chats, online groups, spaces, which is a lot messier than it previously was, meaning that individuals can engage in a bit of anti-Semitic ideology or a bit of an extremist movement without necessarily being a full-fledged member. Membership doesn't look like what it used to. There's no such thing as being a member of an online network in the same way. However, what we often find is that the policies that were built to respond to extremism, often in the post-9/11 environment, take a group-based approach. If you can think about terrorist prescription group models, they look to identify a group and ban it. Now, that's not an unhelpful approach, but it won't meet the challenge of the online environment where lots of these individuals and the majority of this content doesn't come from formal groups. It comes from individuals, networks, online chats.
Yes, and just to give a sense of the scale of the problem, we might call up your report on the Monitor to look at one particular case study that you explored in your report. It's if that report could be called up. It's the document bearing document ID EWR.599.0001.0134. And the page ending with barcode 0010. You can see there at the bottom, this introduces the case study, the snapshot of online anti-Semitism in Australia. And if the operator could then go over to the next page. And perhaps blow up that graph labelled volume of posts, if possible. And while that's being done, can you just give an overview of the case study that you undertook for the purposes of this report, looking specifically at anti-Semitic online content by Australian end users?
Yes, so we sought out to try and understand the trends in anti-Semitism online in Australia. To do this, we looked at a year period, May 26, 2025 to May 26, 2026, specifically from accounts that identify themselves as located in Australia. Now, I'm cautious to note here that that is likely an underestimate of the overall volume of anti-Semitic content in Australia, because the majority of users, you would imagine, do not identify themselves on the platform structures as located in Australia. Typically, for example, on 4chan or on Telegram, a lot of users would be anonymous and wouldn't need to enter that information. We include here only 5 platforms, 4chan, specifically 4chan's poll board, which is short for politically incorrect. It's a known space where extremist networks operate. X, Tumblr, extremist forums and extremist blogs. We use these platforms, and it's clear that this is an omission of a number of mainstream and large platforms where anti-Semitism operates, because these are the only platforms where we are allowed to collect data based on location, or where an individual could note their location. I can dive later on a bit deeper into those data access issues that we face.
Certainly. And just in terms of... Sorry, yes. I didn't mean to cut you off. No, please.
We identified nearly 42,000 posts over that year period. We did this using a classifier which we trained using subject matter expertise and ethnographic expertise. and deployed that classifier onto the data set of posts. This is the number of posts that we surfaced. It's not, and we couldn't say whether it is accurate to the number of posts overall, because we don't have, again, access to that data. But I'd be happy to talk through some of the indications that it gave us about the volume of anti-Semitism over time.
Yes, let's do that. So in your analysis of the data, you note that there are two large spikes in anti-Semitic content on the 13th and the 22nd of June 2025. Can you just speak to that briefly?
Yes, so the 13th of June 2025 was the day that Israel attacked Iranian nuclear facilities and military bases, the start of that initial war between Israel and Iran. And on the 22nd of June was when the US joined in. So it's clear that those spikes in anti-Semitic content from Australian users, and when we did a manual qualitative analysis of the posts from those individual days, we found that there was a high level of discussion around the Middle Eastern conflict. This is not necessarily a surprising finding. We found this across a number of research reports, and other organisations have also found similar findings, that anti-Semitic incidents globally, but also volume of anti-Semitism on social media, peaks around key moments in the Middle East conflict. And we found that particularly around the Iran war.
And I think you also mentioned there was another spike associated with the assassination of Charlie Kirk on the 10th of September.
Yes, exactly. We saw an elevated volume of anti-Semitism on that day, discussions of the alleged or conspiratorial alleged role of Israel in that assassination, and making anti-Semitic claims based on conspiracy theories that Israel had assassinated Charlie Kirk. This, to me, speaks to the relevance of international events to the Australian conflict. Of course, any user based in Australia can access any content globally, and so this isn't necessarily based on national borders.
Yes.
But to me, this speaks to the importance of being able to operate globally in response to anti-Semitism and international cooperation with other states who are facing similar issues.
I might just take you to the next page of the report, which contains another useful chart. So this is the data disaggregated by platform, and you can see 4chan is far and away above the other platforms. I think it accounts for some 82% of the identified content, with X some ways behind at 16%, and then the remainder substantially accounting for substantially less than that. And you note in your report that findings like this suggest that both larger, more mainstream platforms as well as fringe platforms such as 4chan need to be addressed as part of any effective policy response. Can you just elaborate on why that is?
This speaks to the tech stack that I was describing before, where an individual doesn't use only one platform for only one purpose, but engages in a wide range of platforms. And any individual platform approach to this issue will likely fail where there is an ecosystem of social media platforms, providers, gaming services, which function together to exacerbate the issue of anti-Semitism from extremist networks in particular, but also from mainstream communities. 4chan's poll board here is well documented as hosting extremist networks, particularly on the far right. I should say here that this is only the data that we've been able to surface in this analysis. This doesn't necessarily speak to the overall volumes on these platforms, and we would want to also, if we had access to that data, be able to include other platforms where we know anti-Semitism exists. But this is a clear indicator here that regulatory approaches and countermeasures against anti-Semitism can't only focus on mainstream platforms. They have to take into account the role of fringe platforms in the very high harm forms of anti-Semitism that they produce as well.
And before I take you to some of those possible regulatory responses, including greater access to data for researchers, I might just have you comment on the role of recommender systems and algorithmic amplification, which you address in your report, and how they drive anti-Semitism online.
So platform recommender algorithms serve content to users who would not otherwise have seen it. That is part and parcel of social media platforms' business model, to increase engagement and keep you on the platform longer, effectively, with all forms of content, not just with harmful content. We recently conducted a study with the Antisemitism Policy Trust, which is a charity here in the UK, to understand the role of recommender algorithms in serving anti-Semitic content specifically to minors. So we created 10 users of 15-year-old people, 15-year-old kids here in the UK, 5 boys, 5 girls, and prompted each of those users with a different set of indicators. For example, 2 were prompted on generic right-wing ideas and beliefs. 2 of them were prompted on generic left-wing ideas and beliefs. 1 was prompted on some extremist codes just to see what would happen. 1 was prompted based on manosphere or male lifestyle influencer keywords. So none of these keywords had anything to do with the Israel-Palestine conflict, with Jewish people, or with anti-Semitism. We trained the account initially to make sure that the platform understood that it was a 15-year-old, so we were getting generic pranks in school, teachers, that kind of content. We then entered the search terms that we'd identified, watched the top 3 videos relevant to those search terms, and then went back to the For You page and just scrolled and watched fully any videos that were relevant to the conflict, potentially relevant to anti-Semitism as well. We repeated that a few times, that whole process, and eventually we found that anti-Semitic content was being served to those minors. We conducted around a 90-minute process of manual training, and then we filtered for relevance, collected all those accounts, and then we built a bespoke bot to continue watching those accounts based on the indicators that we provided, and we ended up with a large data set of videos which we transcribed to understand the volume of anti-Semitic content that was being served to minors. And what we found that was within that 90-minute training session, a young 15-year-old boy, so a minor, was served content glorifying the IRGC, Holocaust denial content, and anti-Semitic conspiracy theories.
And thank you for mentioning it. It was a document I was going to take you to, and I might just do that briefly to illustrate the point. If we could call up the document EWR.599.00001.0239. This is the report you were referring to, yes?
Yes.
And if we could go to the page ending in barcode 0005. Might be a few more pages in.
Is this the page?
No, it's not. Should have a table on it. That's the one. Thank you. And if you could just magnify figure 1. These are, I believe, the search terms for the dummy accounts that you were referring to earlier in your testimony, correct?
Yes.
And you can see some of them do touch upon Israel, Gaza, Palestine. Others address more anodyne issues such as free speech, and then there are also more suggestive references to Zog, Jewish lobby, Rothschilds. So these were the search terms that the dummy accounts were essentially trained on, if I can put it that way.
Yes, exactly. So there were 2 accounts that did enter search terms, neutral search terms about the conflict. The rest of them did not.
Yes, and then if I could take you to figure 13, which I hope and believe is on page 0012. Might be a page or 2 after that. I think it's the next page to call up figure 13. So you can see here, this is some of the content that was served up to 15-year-olds, the notional 15-year-olds who had the dummy accounts. Is that right?
So these were user-generated stickers that were in the comment section of videos. So those videos which the stickers were on were not necessarily anti-Semitic, but you can see here that these are very overtly anti-Semitic stickers.
Yes.
So we make here the point around the types of content available to users to create on social media platforms, and whether all of those spaces are equally subject to the platform terms of service.
So even if the 15-year-olds are not being directed to videos that are in themselves anti-Semitic, the contents or the comments and the stickers that are affixed to those videos may well contain that kind of content.
Exactly, yes.
You mentioned in your report that AI is changing both the nature of anti-Semitic content online and exacerbating its spread. Can you elaborate briefly on the role of AI, both in moderating through use of LLMs and other AI systems, the content on the platforms, but also as a driver of anti-Semitism online through AI-generated images and visuals and memes?
Yes, so online anti-Semitism is often highly aestheticized. By that I mean that it's not just delivered through a set of messages, but through memes, images, inferred meaning, and that creates effectively an aesthetic culture, which is particularly common in far-right, but also we've evidenced it in digital Salafi ecosystems, where users feel empowered as part of that ecosystem based on the visual aesthetics. And it's often united by that aesthetic, not necessarily by an ideology, but significantly plays a role in the spread of anti-Semitism through memes which use crude humor and desensitize users to violence and to anti-Semitism. We've seen generative AI used by harmful actors to promote anti-Semitism in a number of ways. I should say that images have been used since long before generative AI, so I wouldn't want to overstate the fact that I wouldn't want to say that this has come around in the last few years, but what that has done is made it more accessible to users who wouldn't otherwise be able to make highly viral content. There's a couple of examples I draw upon in the report. The first is a piece of research which we delivered a couple of years ago now, where we looked at the role of generative AI in content about the Holocaust and tried to understand whether we could create Holocaust denial content from a number of different models of generative AI. In terms of Holocaust denial, that's sometimes a bit more difficult, and there were a number of safeguards in place, but
For distortive content, it was a lot more of a complex picture. We managed to achieve creating images of children smiling in concentration camps, for example, or playing outside the bunks of Auschwitz. That's particularly concerning because it's not overtly illegal in any sense, but it does erode that memory of the Holocaust and changes the narrative and means that the facts of the Holocaust are brought into question. And so that is one form of harm coming from generative AI. Another form which we identified recently as well was the use of generative AI to recreate Hitler speeches in English, which went viral and reviewed many times. This is obviously a technology that wasn't previously available and means that Nazi content is available to a wider user base than just those who speak German. And we found hostile states using generative AI in their content. So, for example, we found the use of it from Iranian-linked accounts, which has likely played a role in the ability of that content to go viral. So the first point to make is around generative AI and the way in which that's lowered the barrier to participation and production of viral anti-Semitic content and increased the views likely on that content. And AI is also used to produce recommender algorithms and train those algorithms. And where either anti-Semitic content isn't identified, it's then pumped through those recommender algorithms and served to users who wouldn't otherwise see it. And that creates a false filter bubble where users believe that users are normalized to those ideas because those are the only ideas that they see. We note here a example from the UK in 2024 where an individual who conducted an attack on motivated by violence fixation, an attack on a girls' dance class in Southport. A false name of the attacker was spread online shortly after, where the attacker was alleged to be Muslim and alleged to be an immigrant that had recently arrived on a small boat crossing the channel. That was false and confirmed by the police to be false the next day. But still, when you typed Southport, where the attack had taken place, into the search bar of TikTok, the recommender algorithm served you the false name of the attacker. That went on to play a significant role in what we tracked as the rise of anti-Muslim and anti-migrant hate on social media and eventual widespread riots across the UK against Muslim and migrant communities. So here we can see that connectivity between all those different pieces of harm and platform structures that exacerbate the issue. And finally, AI plays a role in automated content moderation by platforms themselves. And I can't speak exactly to what role that plays because that information is not publicly available. But we know that platforms have indicated that they do use automated moderation to detect and remove anti-Semitic content.
Thank you. Commissioner, I know at the time I have about 10 minutes left in the examination if the Commission is content to sit on. Yes. So having given a lay of the land, as it were, of the nature and the prevalence of this content online, I want to discuss with you now some of the possible regulatory responses that you've explored in your report. So you've mentioned the Digital Services Act and the UK Online Safety Act. Can you just, beginning perhaps with the DSA, walk us through the key elements of the framework as you see them and how they might be adapted for other jurisdictions?
So some of the key, I guess, distinguishing features of the Digital Services Act, which I'll mention here, is the kind of dual reporting system, both for illegal content, but also for content which violates the platform's terms of service. And so you have this dual system where a user is required to actually have quite some level of legal knowledge in order to flag a piece of content to the platform, and then the platforms have a responsibility to respond to that content in a meaningful way. That flagging system is reasonably common across these kind of frameworks. One of the key differences with the Digital Services Act, which we see, is the transparency requirements, where platforms are required to publish transparency reports. And this is really quite significant. This is the only regulatory framework where platforms are systematically required to produce those reports, and so that gives us the best insight that we have into how these platforms are performing in terms of moderation and in terms of those regulatory requirements. They're not quite standardized, they're not quite comparable because of the structures of those reports and what's mandated by the DSA at the moment. But they're the top standard for what's available globally around transparency.
And I understand there are other limitations associated with those reports, including the fact that they don't disaggregate the nature of the content that's been removed. For example, content that's removed will just be classified under one category rather than separated out into, say, anti-Semitic content or anti-Muslim content and so on. Is that another limitation of these reports?
Yes, exactly. So different platforms will take different approaches. X's, a report from INAH that I cite in my report, notes that X's transparency doesn't provide a meaningful link between the volume of illegal hate speech and the number of reports received. So although they'll say we removed X number of reports, that we can't understand that in the context of how many overall pieces of anti-Semitic content were available. Some other platforms take different approaches. Meta aggregates hate speech under illegal content. So we don't even know what form of illegal content that is, and then it's not disaggregated by form of hate speech. So we don't have any publicly available information about the volume of anti-Semitism. It's not placed into context around the overall volume. There's a number of other transparency mechanisms that could be strengthened here. One is around the number of human moderators in different languages, but also in different country contexts. So platforms, for example, will indicate under one of X's transparency reports that there's over 1,300 moderators in English, but we don't know where those moderators are located. And so, for example, would they have the cultural competence or knowledge of the Australian context, or would they all be located in the US? And that's quite an important point when you think about the nuances and the specificities of local forms of hate. Also, that's clear to us, for example, in this X report that I cite, that there's not necessarily the combination of language and subject matter expertise. So Poland in this report was found to have one language moderator for all violative content. That's not just illegal and it's not just hate speech. And in this report, Sweden had 0. So there's quite a disparity across jurisdictions here. And of course, that will impact Australians who speak multiple languages and have dual nationalities, for example. We still don't have any insights on how moderators are trained. Any systematic insights on how decisions are made. We don't have any transparency of algorithmic systems, and we don't have any comparability across different reports. So this is a great start, this transparency regime, but it doesn't quite give us the information we need in order to be able to make those decisions. The other point that I'd be really keen to make here would be around data access for third-party independent researchers. There is some level of requirement under the DSA for for data access, but that is often prohibitively expensive, not fully comprehensive, and means that we don't have a picture of what is going on online. It means that the public is unable to hold these platforms accountable, both for under-moderation and over-moderation. And this is a vital point for ensuring that free speech and democratic integrity is maintained in the online space from both perspectives as well.
And on the point you mentioned about lack of insight into the decisional level content moderation, one of the examples that you draw out in your report relates to Meta's oversight board, where unusually for a social media platform, they have an ostensibly independent body that can examine specific content moderation decisions that are subject to appeal. Can you just elaborate on how effectively that is operating and whether it's a model to be emulated by the other platforms?
It's a reasonably ad hoc model, so individual cases will be taken into consideration across a broad range of harms. There was one case a couple of years ago on Holocaust denial, which was particularly interesting, and I cite in the report, but this is not on a systematic basis by any means. It's the best insight we have into how decisions are made, but does not provide any systematic insight. And so any additional transparency that we're able to garner from systems such as the oversight board from Meta is very welcome, but what we would want to see is some form of systemization of that, because where where platforms don't offer that up readily, it leaves us in the dark as to what is actually going on online.
Yes, and just pivoting to the UK Online Safety Act, you mentioned some of the limitations with the EU DSA. I think one of them that you mentioned in your report is it doesn't quite incorporate safety by design principles in the same way that the UK Act does. Can you just elaborate on the relative merits of the UK approach and where it builds upon the DSA?
Yes, so there's not quite the transparency regime in the UK that there is under the EU Digital Services Act, and that's still getting set up. So first, we're expecting the categorisation decisions, I believe, this month, and then the transparency reports to start, I believe, next year. And I don't yet have an idea of what that will look like. The UK Online Safety Act incorporates more safety by design features, and it also takes a more risk-based approach, which is highly relevant for understanding the interconnectivity which we've discussed between different forms of online content and online harm. Understanding that misinformation, disinformation is of itself not illegal and shouldn't be, but that it can play a role in the exacerbation of and can lead to the promotion of illegal content, such as I've discussed already with the Southport example. And so that risk-based approach there is really valuable.
And if you yourself had to design a regulatory regime from the bottom up, perhaps incorporating the best elements of the DSA and the UK Act, and otherwise unconstrained in your design choices, what would an effective regulatory response look like?
I would emphasise here the necessity of safety by design features, not bolting on safety as an afterthought to a system which was built without consideration, but making sure that that is considered at every stage. I think this risk-based approach is really valuable here, and the key thing which I think can be built upon globally is these transparency requirements, including data access for third-party researchers, but to give the public an understanding of what is going on in a world which strongly applies to them in digital public spaces, and making sure that we can have a say in a democratic sense of what goes on online, making sure that platforms are neither over or under moderating. And we can only do that through an effective transparency regime, which needs to be mandated and set out clearly in a detailed manner through regulatory systems.
Yes. I think you say in your report, transparency is the foundational precondition for every other accountability mechanism. That's really the premise from which everything else flows. Is that correct?
Exactly. We can't do this research without data access. A lot of the research which we try to deliver to understand harm in the online space, we're simply not able to do because we don't have that access. That's the case for recommender algorithms. Let's say we don't have understanding of how that happens online. And so in order to be able to enforce any of this, we need to be able to understand the online space and understand how the systems that we're putting in place impact the online space. And we can't measure the success of regulation or any of these measures without that access.
Thank you. Commissioner, I have no further questions.
Yes, Mr. Bender.
Ms. Rose, Dr. Rose, or Professor Rose?
Miss, not doctor yet, I'm afraid.
Ms. Rose, I appear for 7 of the mainstream Jewish community bodies here in Australia. I have a small number of questions about a very focused aspect of your report. You mentioned briefly in your oral evidence the decision in January 2024 by the Meta Oversight Board that's referred to as the Holocaust Denial Decision. You're familiar with that decision, I take it?
Yes.
And on the one hand, it's a commendable example of transparency on the part of Meta, which operates an oversight board unlike anything that the other platforms do. But on the other hand, do you agree that it revealed some problems in enforcement, at least in respect of the content the subject of that decision that existed within Meta for the period from about September 2020 to January 2024?
Yes.
Thank you. As you understand it, it's right that the content in question was a meme that distorted information about the Holocaust that was posted in about September 2020 and then permitted to remain on the platform for about 3.5 years?
That's my understanding, yes.
For most of that time, Holocaust distortion, starting from about October 2020, was expressly prohibited by Meta's policies, wasn't it?
Yes, they had changed their policies to prohibit against Holocaust distortion denial.
You've referred in paragraph 59 of your report to the fact that there was automatic closure of 2 user reports without human review. Do you remember that?
Yes.
And is it also right that in the decision itself there's reference to a total of 6 reports that were made and 6 reviews, 2 of which were made by human reviewers? Or is that a level of detail that you didn't engage with for this report?
I don't know the answer to that specifically.
But whatever it is, it suggests that certainly in respect of that particular piece of content, there was a systemic failure in relation to Meta's ability to enforce its own express policies about Holocaust distortion, correct?
Given that Meta's policies did prohibit against Holocaust distortion and denial, it should have been able to enforce them against content that was violative of that.
Thank you. One of the consequences of the decision was that the Oversight Board then investigated and found extensive use of the same meme format to spread similar anti-Semitic narratives. That's right, isn't it?
Yes.
Now, am I right in understanding that those things only occurred because one of the people who lodged a complaint online that was then rejected about the original meme then took the trouble to appeal the decision to this Special Oversight Board?
I don't know if that's the case. I would say that there's clearly an issue when it comes to proactive moderation versus reactive moderation based on user reports, and we know that users are increasingly reluctant to report where they believe that their reports aren't taken seriously.
Is it right that had the Oversight Board not acted the way that it did, as far as we know, that meme and the memes like it may have existed on the platform for a very long time thereafter?
They may have, yes.
So whereas while the Oversight Board in this particular decision are a good example of transparency that's being adopted by Meta, this particular example is an indication from within Meta itself that there is really an unknown amount of anti-Semitic content that violates Meta's own policy on the platform, doesn't it?
That's exactly the case, is that we don't have a view of how much of the user reports which identify violative content are incorrectly rejected because of the lack of transparency.
Thank you. And the position's even worse, isn't it, in respect of those platforms that don't have an equivalent independent oversight board, isn't it?
Yeah, exactly. So the Meta Oversight Board is a commendable transparency mechanism, but it's in no way systematic. It's on a case-by-case basis. And the type of indications that you're discussing here are very important to understand on a systematic basis.
And so, for example, TikTok, which you've recently discovered through your sock puppet study, has the propensity to display to 15-year-olds anti-Semitic material in a very short period of time, doesn't have an oversight board that could conduct a kind of investigation like this, does it?
Not that I know of, no.
Thank you. Thank you, Ms Rose. Thank you, Commissioner.
Anything arising, Mr
Nothing
Bashar?
arising.
Thank you, Ms Rose. You are excused. Thank you for your evidence.
Thank you.
Yes, very well. The Commission will adjourn until 10 a.m. tomorrow morning.